Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm here with my friends Bruce from Oregon and Schnitzel Ninja. We might have our friend Patrick, who's another attorney who's been following this case with us for a long time. He might be joining us pretty soon. We'll see. Hopefully he can still come because I know he read this and he had some thoughts on the law that was cited.
Did he?
So, yeah. All right, so if you guys haven't seen the preview for this, there's a nice close-up of me in Laura's latest filing, as well as a screenshot of me and Bruce, and she definitely got my great angles, I gotta tell you. They're stunners, for sure. But she's obviously upset with me about using the word crashing out for her, so I thought it was appropriate to continue characterizing it as such. Anyways, we have a couple of things we're going to read first, the shorter ones, and then we'll get to that longer filing with all that stuff in it. Let me pull this up real quick. I'm not going to be on the camera because I'm sick, and B, I got someone to fix the air conditioning in my house, which means that they broke it. So now I'm sick and disgusting.
No.
Yeah. All right. Let's zoom in on that. Real quick. Okay, so this is just like she's filing here diligence for like she's trying to serve him and he's not at home. Is that what's happening here?
Sorry, say that again.
She's trying to have him served and he's not at home. That's what's happening.
Correct. Okay. Correct.
So his wife and the newborn answer the door. She's holding the baby. Mm-hmm. They're trying to serve him. She said Michael will not be back for a few days. Mm-hmm. Offered to take care of it, but explained that I needed to be a personal delivery. She responded it was no problem and invited me to stop by in a couple days. All right. So he came back. I see. 2 days later. Mm-hmm. Arrived at the residence. No one's answering the door. And then again, a couple days later, I spoke with Michael's wife, who informed me he is in redacted for another however long and will not be available during that time. I assured her that this is not an issue and offered her a business card so she can contact me if she has any questions. So I'm guessing they have to move the hearing, which was supposed to be on what, the 1st?
Correct.
Okay. So that's
he has to be served with, from what I have seen, he has to be and heard, he has to be served within 5 days of whenever the hearing would be.
Yeah. So 5 days is actually kind of crazy. Only 5 days. That's actually nuts. But
yeah, it is.
Especially if you're like, by the way, I want this renewed against you forever. You have 5 days.
Exactly, to prepare. Yeah. It's crazy.
Oh, man. Yeah. All right. And then we have this declaration. Let's see. All the crazy stuff's going to be in the last one. So we'll just get through this really quick. I'm the petitioner in the above captioned matter. Let's see. Okay, this is lame. Let me just move. Oh, she wants to waive live testimony. That's right. And proceed by declaration. So she wants like written statements only. Is that what she's saying?
Yes.
That is stupid as fuck.
And how is that fair at all?
I'm sure she'll explain it for us. I mean, this case involves a long-standing Colette's domestic violence restraining order against respondent Michael Maricini. Okay. The original order was entered October 19th, 2018. To provide additional background, oh God, how many pages do we have? July 10th, 2020, following a contested hearing, the court renewed the order for an additional 5 years through July 10th, which was nuts. The July 10th notice of hearing to renew restraining order.
I want to say too, on that one, the judge only had a choice of 5 years or permanent, and they chose 5 years.
That's ass.
Yeah. Or I guess they could have not renewed it, right? But
yeah, that would have been ideal. But, you know, we got to take Laura's word for it, I guess. I retained a process server, John Hudson, and we just read that. That was the process server trying to serve him. Okay, so I'm not going to bother with this shit. Respondent's refusal to accept service cannot be viewed in good faith. What? They just said he was out of town.
He was out of the country.
What are you talking about,
even
lady?
In the country.
Clearly, his wife knew that he would be out of town for an extended period of time on his attempt on July 21st, but did not inform Mr. Hudson that he was not returning for another 2 weeks. Did he ask? Did Mr. Hudson ask?
He did the first time.
Okay.
I'm not sure about that third time.
Okay.
Hold on, I'm going to mute myself for a minute.
Yeah, go for it. There's overwhelming
Sometimes
evidence.
you got to go out of town for work, right?
I mean, shit happens, I guess. Also, plans change, man. You don't have to, like, you're not required to have a set life schedule. So you're just going to have to go fuck yourself with that one. There's overwhelming evidence that the respondents had actual and timely notice of the filing and the hearing. What do you mean? On July 11th, just one day after my filing was submitted to the court, the group Justice for Clayton obtained it and began circulating my request to renew restraining order and declarations by me and attorney David. So we're admitting that David wrote that. Or are we just saying that he wrote the declaration? Sorry. Declarations by me and attorney David.
I mean, he is in that addendum, right?
Yeah. He copyright struck Snitzel Ninja for it. So on social media, these included screenshots of sensitive court documents and mocked the contents of the renewal request, because the renewal request is fucking stupid. Who wouldn't mock that? But also, as far as I know, Mike is not Justice for Clayton. So what is your problem?
Also obtained it. I mean, public court documents are obtainable by the public. I mean, it's not like some illicit. It's not like somebody handed off a briefcase at midnight under the streetlight or something.
Oh, so on July 21st, she said a couple of days.
Okay.
There's video evidence of this.
Yeah.
And she did not say a couple weeks. She said a couple days. So this is incorrect.
You're telling me she was not entirely truthful?
What?
All right.
Shocking.
Let's see. Justice for Clayton is an organized online group created in 2023 by fans of Clayton Echard, a minor celebrity, and the respondent in the paternity matter I filed in Arizona. What happened?
How is it organized? What's the organization?
I guess she's saying Justice for Clayton is the organization, but as far as I know, it's just a bunch of random people who follow it.
That's what I'm saying. There's no organization.
No one organized me, bitch.
We don't have meetings.
You don't, there's no membership. There's no org chart. There's no card. There's no puka shell necklaces that we all wear. There's
that's a disappointment.
And I'm sure there are some fans of Clayton, but I didn't know of Clayton before this. So on the record, I was not a fan of Clayton Echard.
I watched Clayton's season of The Bachelor and I thought he was a mess, but I did like him. I thought he was a mess, but I liked him.
Mm-hmm.
And now we're married. So, although originally formed to support Mr. Echard, the group has since evolved into a targeted harassment campaign against. Where have I heard some shit like this before? Extending that support to the respondent. I am so done with these entitled fucking. Oh my god. you these people and their harassment campaigns, their smear campaigns, all you have to do is turn the fucking screen off. You don't have to listen to me talk about you. Why, Laura? Why do you sit here and listen to me talk about you all the time? No one asked you to do that. All right. It's hardly harassment.
If you make a video or somebody has a Discord, they're not sending it to her. So there's no harassment because she's not the receiver of something from someone. She's seeking out publicly available information. That's not harassment. That's content consumption. So she's a consumer.
She's choosing to be harassed.
She contributes to my ad rev fund. Thank you, Laura. Justice for Clayton, will you accept my rose, Lauren? Duh. And also, man, I don't want to hear you're married. Don't worry. I am too gay for Clayton, so we're not actually married. So you can sleep easy tonight, knowing that I'm alone. Anyways,
no, don't tell anyone you're alone.
Oh shit, you're right. But you know, it is what it is. JFC members have relentlessly ridiculed and denied the abuse I endured on various social media platforms. I'll admit to that. I've done both of those things because you were not abused, and you deserve to be ridiculed for the bullshit that you're putting out on the internet right now. All right. Abuse they did not witness or have firsthand knowledge of. Well, neither did anyone else. As of my relationship with respondent took place in 2016 and 2017, years before the group was formed. They have exhaustively called the orders issued by the court fraudulent and refer to the respondent as victim. Then sue me, Laura. Prove it. Prove you're telling the truth. Do it. Do it. You think I won't? Listen, I've dealt with way worse people than you by now, so do it.
Like who?
Oh, fuck. I hate you. JFC's
also, it's not illegal. It's not illegal or anything to have an opinion.
Well, you know, celebrities, they might feel differently, I guess. JFC's conduct also includes mocking and publicly questioning my documented physical and mental health conditions because they don't make sense. Particularly my autism diagnosis, you're not autistic. Severe anorexia nervosa, I'm not contesting that one. And my enrollment in the domestic violence brain injury program at Barrow Neurological Institute. You actually don't even have to, no.
You don't have to show any evidence of anything.
Right.
And maybe they'll be subpoenaed and maybe they'll be questioned about
the only program of its kind in the country. Lady, it's not like you got into an esteemed college. Please stop talking about it like that. He's nuts. All right. I am one of approximately 600 participants nationwide and was admitted to the program following my relationship with the respondent.
And following your accident and following you falling off fucking horses.
Is this her LinkedIn profile?
My question is, why did she never on her 2018 DVRO paperwork and on the 2021, why did she never claim seizures and epilepsy? Answer me that one, Laura. Did you forget you were going to claim that? You didn't know you were going to claim that shit yet? And now you're going to claim it now? She didn't claim anything about any of this in her 2 filings.
She leaves shit out all the time. Hang on. Let me text my mom back real quick. Hi.
This doesn't make sense because what are you doing, Lauren? If you wanted to prove an autism diagnosis, you would show your diagnosis.
Right.
But all we have is her word, right? But then at the end she says the respondent is welcome to
I'll sign my HIPAA
challenge
shit over
legitimacy through HIPAA compliant medical record releases. Why do you need to do that?
Just like she complied for Clayton.
Well, yeah. I mean, if somebody says, hey, Bruce from Oregon, I don't think you have a diploma that I have, I would show the diploma. I wouldn't be like,
we'll go find
if the respondent would go through court and look at my diploma, I don't need to do that. I can just show it to you. The solution to speech you think is bad is to counter it with better speech. The problem is she claims to have autism or an autism diagnosis, but it hasn't shown any evidence of it beyond her claim.
No evidence would be credible at all.
And what you do normally when you're looking at things from a scientific perspective is you start with the null hypothesis. You just say, I just start from the baseline, which is I don't assume anything. And then when you make a claim, she's making a claim, we have to see sufficient evidence. Okay. And it's not like, well, you have to believe my claim unless you ask for it through a court process. That doesn't make any sense.
Right.
So when she was doing the HIPAA releases, that's when she gave the apparently wrong Planned Parenthood, right?
Right.
So what does that even mean at this point?
Exactly.
What's up, Patrick?
Yes.
How's it going?
That was a really nice intro. Thank you.
Sorry, dude. That's all I got for you.
I made my day. I'm good with that.
I was excited.
Yeah. I appreciate that. I can tell.
Yeah, we haven't really gotten to the good part just yet. We're going through the declaration, and then we'll get to because I know you had some comments about the stuff that they had cited in the motion to proceed.
Oh wait, how much do you want to fucking bet if I read these on my channel, Jingris is going to copyright strike me again?
All my money, which is not much, but I spent all my money already, so sue me, Laura.
I would do it. See what happens.
I was so interested. Is it even legal to ghostwrite legal papers for someone? And it totally is, which just blows my mind.
Is it? Oh, damn! I should have done that for my business.
The only way it's not legal is if you're writing it in a jurisdiction where you don't practice. You're not licensed.
Unfortunately, Jingris is still a lawyer in California.
She should ask Drake for his guy. Anyways, so we got through that. The special domestic violence brain injury program that she purports herself to be a part of. JFC's narrative. Why are you talking about JFC so much in this declaration? JFC's narrative ignores sworn third-party evidence. In 2018, Karen, is it Imberger or Ilmberger?
Ilmberger.
I've been saying that wrong this whole time. Karen Ilmberger.
Well, which is funny because her name is now Karen Bernatis.
whatever.
So I don't know
it's
why
Karen
she's
of the napkin, as far as I'm concerned.
using the old name.
Napkin Karen, a good Samaritan and stranger to both parties, submitted a signed declaration supporting the initial Colette's DVRO, and she did not submit it on a napkin this time, just letting you know. After witnessing the respondent verbally and emotionally abuse me on a flight to Iceland.
Also,
go ahead.
In one account, Laura claims that Mike ripped up the letter in anger, and then in another account, it said he just got angry and left the room.
There's like 3 or 4 different versions of the story.
Yes.
Yeah.
So it's hard to interpret. I mean, I think this claim that people ignore it is incorrect because clearly something occurred. It's just, I cannot conclude that somebody deserves a restraining order, a DVRO for 5 years or their life based on this story, because how do you validate it?
It's so out of context, and and she didn't see all the shit leading up to this. Laura admitting that she fabricated the pregnancies, admitting that to Mike's future brother-in-law and to her father. Laura claiming she's at an inpatient facility and not at an inpatient facility. Then Laura telling Mike she's not going to come on this trip, and lo and behold, when he gets on the plane, he fucking sees her fucking mug walking down the aisle, coming to sit next to him. And he was like, what the actual fuck? Like, I did not think you were coming. And then she's there, and he says that she ripped his headphones off. She's like just poking and poking and poking and poking and poking, not giving him any personal space. So yeah, maybe he fucking snapped, and maybe he said
You're
something
trapped in a metal tube with that. So what are you supposed to do?
That wasn't, the nicest thing. And maybe it sounded mean, and maybe it did make her cry.
Yeah.
But that's all the context that's missing to this claim, and she's using it as her fucking holy grail.
Yeah. Right.
Yeah, plenty of people have looked at it. I mean, so nobody's ignoring it.
Mm-hmm.
It's very strange.
Let's see. She described his conduct as scary and stated he was so menacing that I felt her life was at stake if she were to stay with him. What the hell? Did she
I'll tell you, Laura and her lawyers wrote all of these declarations and had the people sign them. They did not sign them themselves, or they did not write them themselves.
She gonna get Napkin Lady back?
Well, somebody will.
Okay. All right. On July 13th, just 2 days after JFC began circulating my Colette's DVRO, which again is not a crime, renewal filings online, the respondent launched a GoFundMe campaign to raise money for legal fees. Okay. And the campaign has raised over $10,000 to date.
$17,000 now.
Yeah. With nearly all contributions coming from members of the JFC community. Why is that necessary for you to include in here?
Right.
Well, how do you verify that claim?
Right.
That's a weird. You go to GoFundMe and there's just sort of names or anonymous donations.
Laura,
this is an unverifiable claim.
Mm-hmm.
Laura, I donated to your father's GoFundMe under Chase J. Jones. That doesn't mean shit. Again, sue me. The campaign has raised over $10,000 to date, with nearly all contributions coming from members of the JFC community. His public engagement with those attacking me shows he is actively monitoring and participating in content directly connected to this case. Again, not illegal.
And
the respondent's active collaboration with the JFC group long predates this current proceeding. On July 24th, 2024, he appeared in a podcast interview with JFC content creator Megan Fox. At least she's not a blogger this time. One of many creators who have monetized over 1,000 videos attacking me. I don't think she's monetized over 1,000 videos. Attacking me since I filed a paternity case in 2023. Well, you left out quite a lot of detail there, but all right. During the interview, which can be viewed at, and there's a link, the respondent openly admitted that he, and we'll get more into this, but he knew he wasn't going to be testifying at the June 10th hearing. This admission directly contradicts JFC's public narrative, which claimed that respondent traveled interstate in response to a subpoena. He still did.
I think what he meant is time-wise, and I don't know, I haven't gone back and watched this video, but I know what he meant was time-wise. There wasn't going to be, he found out there wasn't going to be enough time, or maybe he was even told, you might not testify, but we are going to have you there in case we do have the time to get to it. So here's your legal subpoena. Yeah. And you still have to come. Exactly.
You can't just be like, no, I don't think so. There's only 2 hours, bro. I don't think I'm going to show up.
Both things can be true at the same time. You can have a subpoena, you can respond to the subpoena, you can go, and you can look at the schedule on the docket and say 2 hours, and we have to get through Clayton, Laura, Greg, 2 expert witnesses. I'm very skeptical that I'm even going to make it up there within 2 hours.
Right.
But still, you're legally bound to go. So both things can be true at once, and she's ignoring that.
Right. Why do you think she never mentions his legal subpoena?
Right.
That's what she said.
What?
What Bruce was saying about like the unverified claims, like the anonymous claims, I think it's just so relevant that like we live in for now we live in a country of laws, and it's like if you're going to introduce evidence, like you've got to subpoena the custodian of records, you have to allow them to be subject to cross-examination. So like all of these are just allegations, aka words,
right?
But I'm curious if they're signed under perjury. That's why I'm looking at the docket or at the filing now to see, could this potentially get her in more hot water?
Yeah,
I would think so. I mean, this is a huge list of allegations. It's just an enormous list that opens the door for an amazing amount of discovery, right?
Yeah. I mean, all of this stuff has to be subject to cross-examination. That's what I don't get. Yeah, right here at the bottom of it. I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. It's like, really? Because then if we go and subpoena, and that's what pisses me off about this, like in terms of Mike, because it's his duty to refute that. And it's like, so he's got to waste the time subpoenaing Google. All that.
Who would subpoena Google? Just saying.
Sometimes it's warranted.
Yeah, all right. I'll let it go.
Not in your case.
Well, what about claims you can't even prove? Like, how do you determine, even if you have an arbitrary list of everybody who contributed to the GoFundMe, which you don't because they're anonymous donors in there, but if you had a perfect list, what is the scientific test to determine whether someone is JFC or not? I have no idea. It's not something that's verifiable. Like, you can't make an Excel spreadsheet and either prove or refute her claim. It's just,
and that's why she wants to argue it on the paper, because then all Mike can say is, well, this is utter horseshit, but he can't, put her on the stand and say, okay, we're going to go through however many 100 donations. Who is this person? How do you know they're a member of JSC? Who is this person?
Who has hogged my meat?
Where is your Excel spreadsheet?
Yeah.
Show it to me.
It's just all, I mean, it's like rules for thee, but not for me.
I think that's her motto in life.
She's got a tramp stamp of that somewhere.
Oh my god, me too.
Yeah, in the same spot.
Like there's a lot of emotional appeals in here. I think Echoes was saying in chat. That's something to keep your eye out. When is something in here an emotional appeal versus something we can actually quantitatively verify?
I would have just gone, when the fuck is it relevant? Because none of this matters at all to her declaration.
It's her own fault. People are picking this all apart. She chose to go public with her case with Clayton. That was her. That was her fault.
To leave that out, yeah.
And we'll get to this when we get to the actual pleading, but the fact that she requested to file it under seal incorrectly, and then it got released, is just
incorrectly. She finally got David's advice on this then.
And that's what hit me. I was like, David talks all this shit, and I'm like, dude doesn't even know the correct procedure to file something under seal.
Also, if she wrote this herself, there's no fucking way she didn't run it past him, because I think she'd be afraid to run it past Josh, and I think she would be ecstatic to run it past Gingras.
Oh, because she loves positive reinforcement. Yeah.
God. All right. Where do we get through on here? In truth, the respondent violated the terms of the existing CLETS DVRO by appearing in person at the hearing without prior permission from the court, or this court, I guess, as explicitly required by the order. Because the restraining order was issued by a California court and extended under the VEWA, its terms were fully enforceable in Arizona under the full faith and credit clause. His unauthorized interstate travel and physical presence in the same courtroom as me, well within the 100-yard stay-away provision, constituted a direct violation of both state and federal law.
I guess Mata and all the 3 different police departments didn't understand that.
Yeah.
I guess they're
They
dumb,
were all
right, Laura?
wrong. What the heck?
Given the totality of the circumstances, including the respondent's awareness of this proceeding, his refusal to accept service, it wasn't a refusal, and his past violations, I respectfully ask the court to do one of the following. Continue the hearing to allow further attempts at personal service, and that the restraining order remain in effect until that continued date, and, even though she's asking for one of the other, and grant my motion to proceed by declaration as filed on July 23rd, which would eliminate the need for a live hearing and would protect me from the re-traumatization of direct confrontation. Lady, shut the fuck up.
Yeah, and is both things, not one of the following.
Right.
So this isn't even written properly.
No. That's stupid as hell.
Oh.
All right. So we're getting into the good stuff here with this one, but let me just a minute real quick. I'm going to turn my mic off for a second. Okay.
Are we supposed to be entertaining? Or
no, I just turned the fan up, but hopefully it's not too loud. Please don't. Please don't do that. Okay. So she wants to waive the requirement for live testimony, even though she's asking for like a forever restraining order and referral for prosecution, which is just ridiculous.
How about can I I want to send you something. Hold on. Can you display it real quick before we move on?
It's not going to be anything like the last few things you sent me, is it? Because
no, trust me.
Okay, got it.
Is it a waffle?
Oh, now I'm interested.
So it's on page 2.
Okay.
Oh, sorry.
Of this?
I sent that. No, I sent it to the wrong person.
Wow.
Shit. Don't read that either. That's the wrong thing.
Okay.
There you go. Sorry. Too many windows open on here.
I usually don't open your messages unless I know it's a passage from one of your diaries, but yeah. 1 sec.
So yeah, second page.
Here.
Yep. Just read that first full paragraph.
Here with one last thing.
Yep.
Okay, one last thing. After talking with Laura about this, she said she has lots of questions for Mike. I told her my preference is to have her send me any specific questions, and I'll see if Mike wants to answer them. She also said she's willing to speak directly with him, but that may not be appropriate.
If she's so fucking worried about him and he's so terrible and she can't even show up in person because she's going to be re-traumatized, why the fuck would she offer to speak with him directly?
Yeah, that's true.
Sorry, I'm impassioned. I swear a lot.
No, you are fine. Don't worry about it. I think that you're safe and among decent company with me as far as the swearing goes and all that. So.
Maybe she was going to use a fax machine.
A fax machine?
Yeah, you know, fax.
It's probably what she'll say. Speak with him directly. Yeah, I meant
telegraph, Morse code, telegraph. I don't know.
But she's like, it's just that, like, if she's saying that she's this afraid, then why would she try to even offer in any way, shape, or form to speak with him directly?
I don't know. That's nuts. It doesn't
make sense. I mean, it's proving she's lying.
Yeah.
I think she was probably fucking excited to see him in that courtroom.
Oh, yeah. No, absolutely. You can tell.
I mean, yeah, they didn't invoke the rule of exclusion.
She did not seem bothered at all until people started laughing. And by people, I mean the courtroom staff started laughing when she said it's not a big deal that she lied about her, doctor's appointment?
It's a minor thing.
Yeah, it was that's like a very minor thing. Yeah. So, okay, so this was what Patrick was talking about. It's funny that she said petitioner further request this motion be sealed, and she did it wrong. Pursuant to California rules of court, whatever, due to the inclusion of confidential medical information and escalating threats from a harassment group known as Justice for Clayton. All right.
Wait, putting it in all caps isn't how you do it?
I think that usually triggers it. I don't know what happened. I don't know what.
I've been doing things wrong for a long time then.
Yeah.
Some sovereign citizen shit right there.
Yeah, I mean, I'm a traveler on the land, and I need to seal these documents.
Yeah.
Big shout out for that movie though, that just came out with Ron Swanson, Nick
Nick,
whatever his name. The movie's
what is
called
his last name?
Sovereign. Totally
yeah.
worth watching.
I haven't seen it yet. Yeah. All right. Could I ask? Let's
Nick
see.
Offerman.
Schnitzel,
Yes,
Schnitzel
Nick
Ninja.
Offerman.
Could you read this introduction?
Yes,
part?
introduction. Okay. The case arises from a stipulated domestic violence restraining order, DVRO, issued by this court in 2018. After the initial order was violated by respondent Michael Maricini, this court renewed. That's not why they renewed it. They did not say he violated anything. They just said that she appeared to be in fear because she said she was in fear, and that's why they renewed it. They did not say he violated it. And renewed the order in 2020 for a period of 5 years. Petitioner now alleges Mr. Maricini committed multiple additional violations of the renewed order, including traveling from California to Arizona in June 2024 for the purpose of intentionally violating the order, false, under a federal crime of violation of 18 U.S.C. 2262. For that reason, which is false, Petitioner asks this court for relief, including extending the order permanently, issuing an order to show cause why respondent should not be held in criminal contempt, and ordering that respondent be referred for criminal prosecution. For the reasons explained below, the requested relief is based on facts which are or should be entirely undisputed. Respondent cannot and presumably will not deny that in May 2024 he released publicly released nearly, now it's nearly and not all, 2,500 pages of private confidential text messages between the parties. He didn't release that. Show me where he released that. And that he did so despite never being compelled or permitted to do so by any court order, subpoena, or by any other legal requirement.
I don't understand why it doesn't have to be a legal requirement. This man is a human being.
Right.
He has autonomy, believe it or not.
And they were sent to Woodnick Law.
Not for the purpose of harassment. So
exactly.
It's just like, why?
How does she know they weren't distributed by them? How does she know Gingras didn't distribute it?
It's just very clear to me that like her reality does not match with
anyone else's.
our collective conscious.
Mm-hmm.
Yeah, I mean, this guy went to a court hearing as a witness under subpoena to her fake baby case. Put him in prison. Come on. I mean, it's obvious, right?
Right. Right. And he would have been arrested there had they found he was in violation, or he would have been removed from the premises.
Well, yeah, it's a proof by refutation.
Sorry, Bruce, go ahead.
It's proof by refutation. Like 3 different jurisdictions said, okay, Mike is here. What do we got? What's going on? We have a subpoena. There's a California DVRO. Well, he's in a courtroom. There's bailiffs everywhere. It's fine. Okay. If she was correct, somebody would have arrested him.
Yeah.
Well, I thought about it because it's just, this has been bugging me. Like, why is this continuing to be brought up? And like, why is Gingras going along with it? And I figured out like the reason that this dog won't hunt is because Gingras is just, again, inherently a terrible lawyer. If it were my client, right, and all of this was happening on the day before trial, I have a motion prepared, an emergency motion prepared to be submitted to the Superior Court asking to stay the proceeding until we can adjudicate whether or not the fair faith and credit clause applies to this restraining order. They would have postponed the hearing because there was an interlocutory appeal. They would have adjudicated the appeal. I'm probably using the wrong words here, but like all Gingras had to do was type up the simplest of pleading, asking to stay the pleading until they could file the interlocutory appeal to adjudicate whether or not he could be in the courtroom. And they didn't do that. He tried to do every other shortcut in the book besides what is like legally required. You know, it just reminds me of all these litigations that we see in the federal courts around the Trump administration. Like, these people are working around the clock to make these filings. And so like Gingras wanting to just, you know, flash his like 1990s duckbill haircut is like not gonna cut it. It's just a bad lawyering.
Yeah. Okay, despite never being compelled to or permitted. Okay. Further, respondent cannot deny that in June 2024, he traveled from California to Arizona with the intent to violate this court's order, and that he actually did violate this court's order by coming within 300 feet of petitioner. Because these facts are either undisputed or not subject to any good faith dispute, there is no factual disagreement for this court to resolve. Oh, really? Rather, any defense respondent may raise presents purely a question of law, i.e., does respondent have a valid legal excuse for his actions? It's called a fucking legal subpoena. Is she this dumb? Is Jingris this dumb?
Yes.
I
How
think
are
she
they
doesn't
so
understand that the court system is adversarial. You can't just like say, hey, this is how it is. Trust me, bro.
Right.
You have to actually have the adversarial arguments back and forth.
And Jingris
for a
tried
judge
that,
or
and look
jury
what
to
happened to
decide.
him. Everything was denied.
Yeah, exactly.
Because this case presents only legal disputes, no factual disputes, this court should exercise its discretion and exclude live testimony pursuant to blah, blah, blah. Good cause exists for this request because the material facts are not in controversy. Live testimony is not necessary for the court to assess either side's credibility. And other facts exist which would make live testimony unnecessary and inequitable.
Are we sure she didn't just use like ChatGPT or something?
You can't write in a filing, hey, I'm the petitioner. I'm going to tell you what the respondent concludes or thinks. Like, no, they have to tell you what
and what you should do.
This doesn't make any sense. It's like she's saying, I'll just tell you what they think. Trust me.
Mm-hmm.
It doesn't make sense.
I mean, I know it's a piece of advocacy, but it's incorrect to say that it's only a question of law. Like in law, we have questions of fact. You know, was it a Tuesday when you said it was a Tuesday? We have questions of law, like did you have a contract? And then we have questions of law and fact, which is, did your conduct, which is a fact, constitute harassment under the law? So it's not a child could refute, or a second-year law school student could refute a lot of these arguments, but they sound really good on paper.
Mm-hmm.
So
I don't think they do, because there's no backup evidence for it. Like,
but it's
not
so
convincing on its face, right? It's declarative, but I don't care about declarations. I care about independent verification of evidence.
I guess you'd make a better judge than me, because I'd be like, they sound really confident.
I think she sounds completely confident. Yeah.
Yeah, that's called bullshitting, when you're very confident about something and you're not sure if it's right or wrong. You're not lying. You're just trying to throw it out there and be really confident about it. That's good. She's very good at bullshitting.
Yes. Do you want me to keep here?
Yeah, if you are good with that.
Yeah. To procedural history and existing order. The background facts of this matter are as follows. On August 3rd, 2018, respondent stipulated a 2-year domestic violence restraining order issued by the San Francisco Superior Court. Notably, no evidentiary hearing was held because respondent stipulated to the order at the behest of his lawyer at the time. On September 11th, 2020, the DVRO was renewed for an additional 5 years following a hearing before the Honorable Judge Sharon Reardon, who found that petitioner continued to experience reasonable apprehension of future abuse. Now, that is correct. What she said earlier was not correct, that he violated it.
Okay.
On July 9th, 2025, petitioner filed a timely request to renew the DVRO again, this time citing not only continued threats and harassment, but new egregious and federally prosecutable violations.
Good Lord.
The FBI.
Please don't call the FBI again.
I'm curious if they can take that into account, like all of those prior events. Like, can the judge take that into account when considering whether or not to extend the restraining order again? I guess they could, because it's all related to the same matter. So those are shitty facts for him, but I think he's got a reasonable explanation.
And he never fought it, which is his saving grace right now.
Yeah, but I think you can take a negative inference, right, from that. The court could.
You could, unless, I mean, in one of his filings, I mean, he can say why he stipulated to it that he has, that he never agreed that he committed any of those acts of violence against her. But because he didn't want to have to deal with her anymore, didn't want to be in her crosshairs anymore and targeted by her anymore, that he would just sign it to like get her the fuck away.
Yeah, and so right there, we have a material dispute of fact that the judge has to weigh before they can make a decision.
Mm-hmm. And then see what she's done in all these other fucking cases. Like, do you see why I didn't want to be involved anymore?
Yep.
On July, respondents' new violations of the extended DVRO. On July 11th, 2025, petitioner filed a request asking this court to renew the DVRO permanently. This request was supported by declarations from petitioner and her Arizona.
Wait, hold on. So
counsel.
Shortly before she's a stickler for detail, and I noticed she's not including a lot of detail here. Shortly before that was filed, what was your Arizona counsel doing, Laura?
Oh, I wonder. By the way, everything's still being processed.
Okay.
It was checked on yesterday.
Okay.
These declarations explained that in May-June 2024, when this court's order remained in effect, respondent violated the order by, traveling from California to Arizona and coming within 300 feet of petitioner in the parking lot of the Maricopa County Superior Court in Phoenix. Petitioner alleges that by engaging in interstate travel with the intent of violating this court's order, respondent committed a federal crime in viation of 18 U.S.C. 2262.
How are they going to prove that? That's what I want to know. How are you going to prove 300 feet? You're either going to, one, have to get Laura to come in and testify, which I guess she already did by saying that, or two, you're going to have to get Gingras, which means Gingras is going to have to file a motion with the criminal court to leave the jurisdiction to serve as a witness for his client who's under criminal indictment. Oh my god!
Wait, for what? June 10th?
Yeah.
No, I'm sorry. I'm crying. I'm working through like how are they going to prove 300 feet? Right? They have to prove that
in the parking lot, right?
Yeah,
in the parking lot or in the courtroom.
Well, this one said the parking lot.
This is the allegation has always been that she had her measuring tape. She's very good at measuring. And she saw him come within 300 feet, which is such a technicality. But then you're going to have to prove that up, right? Like, or do you
her mom was there. Medchill was there. You don't need Gingras.
And she stayed at the very, very back of the parking lot. And he got dropped off right at the front of the building. And he was with his wife the entire time.
So Mike's got a rebuttal witness. And I think they can compel Gingras to testify. He's a declarant.
Yep.
So I cannot wait to see that filing of, can I please go testify for my girlfriend? Client in California.
Former client.
Also, when Mike got dropped off, wasn't he beyond those concrete pillars?
It was like right at the pillars, right? Like as close as you could get to the sidewalk.
The chief of security was basically like, where the pillars are, that's where the court starts. So, for example, they wouldn't let us, like, if we had a video camera or something, he's like, you can't go past these concrete pillars. Because at that point, you're on their ground, right? So,
okay.
Yeah, it's gonna.
Mike may have never even been in the parking lot.
And I think Megan actually pulled up photos.
She did of him getting out.
Somebody says that she did on a stream.
Yes.
She has the photos of where both of them were in the parking lot.
Yep.
Yeah. But at the beginning, when everybody was waiting to go in, he was beyond the concrete pillars. Now, at the end, I don't know, because who knows when everybody came out. I don't remember.
Yeah.
Yep. Where was I? Okay. These declarations further explain that respondent engaged in other independent violations. Is this right? Yeah. Court's order by posting threatening messages on social media, by releasing private information concerning respondent and her family, and by engaging in other threatening and harassing conduct, which included publicly releasing, now it's all 25,000 or 2,500 pages, and it's not even that long. I don't know.
I thought that they weren't your text messages.
Pages of private text messages.
Pages of private text messages
exchanged between the parties while they were dating in 1617, which contained private sexual and medical information. This conduct, which
Where do I get these pages?
What?
Where are they? Where do I get them?
They're not actually all public pages.
No, I've never seen
There
that.
are 2,500 publicly released pages.
No.
Where are these pages? Show them
I
to
would
me.
read the hell
I
out of
wanna
that
see them.
too.
I've never seen 2,500 pages publicly released.
No,
Where are
me
they?
either. Me either.
I mean, we went
Okay,
through maybe
so I
a
don't believe
couple
this
hundred.
claim.
We went through maybe a couple hundred, and those were nutty, and I was exhausted at the end of it.
I was exhausted. Oh my god.
Yeah.
Yeah.
You spent like 2 days analyzing a freaking gurney or something.
2 days is a lot. It was more like 2 hours.
A lot.
And
Thank
to
God
be,
Thank God we
to
had
my
IT
credit,
goatee.
while I was analyzing that gurney, I found that the lot number on both pictures was the same. So I know she faked
Yes.
it.
Mhm.
Yep.
That was your Fiverr moment.
So you're
That
fucking
definitely.
welcome.
That was
Yeah.
good, yeah.
Yep.
Oh yeah. No.
But I mean, even if it was 2,500 pages of text messages, so what? It's not illegal, right?
Right? It's not.
Who
And
cares?
it's not, and it doesn't mean it's harassing, because guess what? It's his opinion that it's fact that he was a victim of yours and that you're not a victim. So he's releasing that to, if he did, to clear his name, which obviously, like we
Right.
said, it's not released. I'm just saying, if he released the whole thing, it's to refute all of the lies and bullshit she's claiming. And again,
And
that's
she's
not
making
illegal.
an assumption about intent, which I think is not you have to prove intent. You can't just
Right.
make an assumption about intent.
Right.
And so this is all teeing up the misinterpretation of law that's coming. That she's saying by virtue of releasing these text messages, that in and of itself constitutes harassing behavior sufficient for the lifetime restraining order. Just to orient everybody. Sorry.
Dumb as hell, but all right. I mean, I know what you mean, though.
Yeah.
All right.
Okay, wait.
So we went.
Did you move it?
I don't think so.
Okay. The conduct, which is all undisputed, is per se sufficient to support the relief petitioner seeks. Indeed, for the reasons explained in remarriage of Ned Carney.
I guess that's right.
Not Carney. Okay. Mr. Maricini's conduct is, as a matter of law, sufficient to grant the requested relief. Ned Carney involved an allegation that a former romantic partner violated the Domestic Violence Protection Act by, among other things, accessing private emails of his former partner. That's not this. Mike did not get on her computer and access her
He's not
emails.
a hacker.
The
He's
trial
looking at his own laptop. He's not accessing
Right.
her laptop.
Right. The trial court initially dismissed the petition, explaining such conduct may very well be illegal, but I don't think that it rises to the level of conduct that is amenable to the Domestic Violence Prevention Act. The Court of Appeals reversed, holding physical abuse and threats are not necessary to support relief under the DVPA. Rather, other types of psychological threats, such as accessing, releasing private messages, are sufficient. The plain meaning of the phrase disturbing the peace of the other party in section 6320 may be properly understood as conduct that destroys the mental or emotional calm of the party. I have a question. Do you think she's trying to get JFCers who have shared any of this stuff to come out and write like affidavits to say like, that wasn't Mike, that was me, and then have to get their names?
Huh. Interesting.
I
In
thought about
terms of
that
what?
too. Yeah.
Huh.
What'd you say, Bruce?
In terms of doing what? An affidavit saying what?
Well, basically, like, Mike didn't release these, I posted these on blah blah blah. Or
Wait, wouldn't it be on her to prove that he did it? Why is it not on her to prove that he did that?
yeah, maybe he can say like presents no evidence that it's not me, but maybe because she's making
Then she
the
can
claim,
subpoena like Reddit, like her stupid ass lawyer tried to, and get smacked down the way that he did.
Yeah.
I love that if we apply the facts of her case to the facts of this case, it would be like me accessing my ex's email account to read only emails that her and I sent to each other. Like,
right. And why?
seem...
Then why would you do that? That doesn't make any sense.
Yeah. I've got them.
Yeah, right. I've seen them.
I doubt this case has anything to do with the case we're in now.
Right.
It's not even persuasive.
No. I mean, I feel like it's very obviously different.
Well, I'm convinced
that she's a liar.
No.
Okay, where was the Court of Appeals reversed? Okay. The plain meaning of the phrase disturbing the peace. All right. Okay, at 1487, the court concluded with the following summary. Do you want me to read this or no?
Now we can skip it.
Okay. In conclusion, so it's a bunch of bullshit that doesn't apply here. In conclusion, the Court of Appeals observed, quote, the trial court was not required to allow oral testimony by Darshana's witnesses because the general rule is that the trial court is empowered to determine motions upon affidavits and has the discretion to refuse oral testimony, end quote. For the same reasons described by Ned Carney and California Rule of Court 5.113, this court should refuse oral testimony and rule based solely on written submissions, including declarations, affidavits. Oh, should they? The rule provides in relevant part factors. Do you want me to read all these?
That block quote, though.
This one or that one?
I know we skipped that block quote, but that was like
the big one?
My comment. That huge one, yeah.
Yeah.
I think this is where not only is are the facts distinguishable from this case, but the holding in this case was if we read the first sentence in the present case. This is the Court of Appeal saying this is what we're deciding. What we have to decide is whether what is written on the application is sufficient to show abuse. And then they say, we're not actually going to decide whether or not this constituted abuse. So that right there is completely different than what Laura is trying to use this for. They say, we assume without deciding the truth of the allegations that the conduct was sufficient to at least pass the smell test to like get I call it opening the door. So like the person tried to open the door to the restraining order and the lower court said, no, you can't even open the door. That's how bad your facts are. And then the appeals court said, no, you can open the door with these facts, but it doesn't mean you're going to win. So you have to, redo the whole thing. So for her to say, this shows that emails constitute harassment, and it shows that the Court of Appeals is saying, and it's such clear harassment that you don't even need to take testimony, is just like, wow, bad. It's pro se bad.
Okay.
It's pro se bad.
So David wrote it.
Exactly. David Drinker's bad.
Yep. It's really bad.
Sorry, not sorry.
All right, so we can go back here to.
Okay, so this is will you go back up? Is this live testimony? Live testimony. Okay, factors. In addition to the rules of evidence, a court must consider the following factors in making a finding of good cause to refuse to receive live testimony under Family Code Section 217. Whether material facts are in. Why didn't she include one? Whether, I guess it didn't apply. Material facts are in controversy. Whether live testimony is necessary for the court to assess the credibility of the parties or other witnesses. 4, the right of the parties to question anyone submitting reports or other information to the court. 6, any other factor that is just and equitable. Where did Bruce go? Oh,
he's right there.
There he is.
My Wi-Fi is not as good as I thought it was.
Oh no,
you're right.
Based on these standards, good cause exists for the court to refuse to receive live testimony for multiple reasons. First, the primary facts supporting relief are or will be undisputed. What is she even talking about? Respondent cannot dispute that he traveled from California to Arizona on June 10th, 2024, and that he violated this court's order by coming within 300 feet of petitioner. Because that fact is undisputed, there is no need for this court to receive live testimony with...
I dispute it. I dispute it.
With respect to that event. The only relevant issue is whether respondent has any legal defense for his conduct. This live testimony is unnecessary for respondent to explain his position or legal arguments. He may submit a declaration and written briefing offering any explanation or defense he believes proper. Go ahead, Patrick.
You go ahead. I don't know if you have any comments on that.
We can't hear you.
Muted.
Oh, he's muted.
Sorry.
I was like, dude, I swear he's talking.
Yeah, no, I had my other mute button on. I was just reading through the factors, like why she left out one. But no, was there a legal question or a legal
no,
comment?
it looked like you were thinking something, but I guess you were just maybe reading through that other stuff. I thought maybe you had a comment. Okay.
Sorry. Yeah.
That's okay. Second, respondent has openly admitted that he did not travel to Arizona for any legitimate lawful purpose. Indeed, just days before he violated this court's order by traveling to Arizona, Mr. Maricini appeared in a 2.5-hour interview in which he admitted he knew he was not traveling for the purpose of testifying in court. Quote, I knew I wasn't going to be testifying. Her attorney definitely thought I was going to be testifying.
That's misinterpretation of his statement.
Mm-hmm. And out of context.
Didn't he say right before that, like, given the time constraint, like, I mean, he said I knew, but he really meant I figured.
And he was probably saying, and Gingras knew with a 2-hour time constraint that we weren't going to be testifying. Like, everyone knew that since it was just 2 hours.
Gingras didn't know what the fuck he was doing that day. Jesus.
Right.
4 minutes on some introduction, and Mata was like, yeah, no, thank you.
Yep. We're done. I'm going to be on vacation, so could you just wait to make your findings? Oh, all right. Respondents' disregard for this court's DVRO did not end there. In that same June 19th, 2024 interview with the content creator Megan Fox, Mr. Maricini escalated his retaliation by publicly defaming Petitioner, misrepresenting the facts of the DVRO. Who's actually done that? And disclosing protected private health information. Among other things, Mr. Maricini stated, it's the stipulated DVRO, completely fabricated.
It is fabricated.
That's a fact. That's not a fucking fabricated fact. It's a fucking fact.
Right.
None of what she said actually happened. It's all fiction. Again, that's true. But we weren't there. How do we know?
We weren't there, but neither was the snow in Iceland the day she said it was. So who cares?
I mean, I hope that we raise enough money where he can bring in an expert to talk about like reactive abuse, because I think that plays a huge unspoken role here.
Yes, absolutely.
Does. I mean, I think I brought that up before, actually, when I was on Megan's one time. But that's something that, unfortunately, it can make you look like a really bad. It can make you look like, to bystanders, the bad person. Like you're the person who's being horrible and yelling at this person and saying all these things. But it's like when you take so much abuse, it's not uncommon to snap back at some point.
Like on the plane, probably.
Right. Exactly.
Actually, wait, he has an expert. His wife is a psychiatrist. So she can my cousin Vinny this shit.
I think she's a child psychologist.
Yeah,
well, she probably shouldn't. She probably shouldn't be an expert in his case, to be honest.
No, she does. No, it's my cousin. It's literally the plot of My Cousin Vinny.
Yeah, but this isn't My Cousin Vinny, bro. I gotta watch that movie, by the way, because I haven't.
Child psychology might be more applicable to Laura in any case, right?
For sure, especially in the abuse context. I mean, not like saying anything about her and her past abuse or anything, but just like in the sense that children are at a higher likelihood of suffering abuse.
Right. These statements are not mere opinion. They are deliberate denials of judicially established findings. The San Francisco Superior Court issued the DVRO after reviewing sworn evidence. How about her claiming that like Mata is a liar and that none of that shit that was found in that case
disagree with the court. Exactly.
Right.
She disagreed with the ruling and the appeals ruling in the Clayton case.
Yep. Publicly posting about it online.
There's nothing wrong with disagreeing with a
it's
court
just not
ruling.
wrong for her to do it. Like
double
Patrick was saying.
standard.
Yep. Rules for thee, not for me. Okay, Superior Court reviewing sworn evidence, a declaration from Karen Ilmberger, a neutral third-party witness who recounted a terrifying incident she witnessed on an international flight. I remember that Mr. Maricini was emotionally and verbally abusing Miss Owens for a long time. You know what he was doing? He was hiding in the bathroom for fucking hours to stay away from your fucking face, bitch. He was so menacing that I felt her life was at stake. Were she to stay with him? Why wouldn't she have written that down?
If you thought somebody's life was in imminent peril,
talk to the police when you
note
land.
on a napkin. You would call the police or dial 911, or you would do something. You wouldn't just write a note on a napkin.
Let the flight attendants know that like they need to contact the police when they land because there's an abusive situation.
Oh, yeah.
Patrick.
He's still there. I think he's just off cam.
Furthermore, during the same interview, respondent publicly disclosed petitioner's sensitive mental health information. You
disclose that shit to everyone all the time. What are you talking about?
She was threatening to harm herself. That's what we were dealing with.
When are you not threatening to harm yourself?
Oh my god.
He's not a medical provider and he's not a lawyer, so he can't disclose confidential information. If he had an experience where something happened between them or he learned something from her, he's not obligated to not disclose that.
I don't think she understands how HIPAA works.
No,
first,
she doesn't,
like you said, he's not a doctor. And second of all, it's fucking fake.
So if I say, oh, my mom had, or my coworker had the flu last week, did I violate HIPAA?
Apparently.
Like, what?
Like, what?
That's what she would have you believe, yes.
And I just want to point out, HIPAA only relates to when you provide personal health information to a medical provider that is subject to the law.
Right.
If you provide it to, a third party survey does not implicate HIPAA. So if you're having a private conversation with someone, they are not subject to HIPAA.
Right. Why does she? I don't know why she doesn't understand that because she's constantly throwing that around.
I think she understands it. She's just so nutty that she's going to pretend she doesn't.
And Jan is probably so over it. She's like, yes, honey, here's the chocolate. Yes,
here's the chocolate.
Here's the chocolate. The dog shitting on the floor again. I don't know why she has a New Jersey Jewish woman's accent in my head, but
I like it.
These aren't legal arguments. They're emotional arguments.
Mm-hmm.
They're all emotional arguments for Laura.
Yeah. This disclosure made without petitioner's consent and outside of any legal proceeding constitutes retaliatory psychological abuse, a prohibited form of conduct under California Family Code 6320, which defines abuse to include harassing, disturbing the peace of the other party, and releasing. How about when you fucking called CPS on Mike? You don't think that was disturbing his peace? And releasing confidential information without consent.
Releasing confidential information without consent. What about when your lawyer posted all your relationship photos in an old podcast with Mike?
I guess he had her consent.
Right.
She didn't care then.
Also, for something to be confidential, it has to mean that you protect that information in the normal course as confidential. Right. But she's out making TEDx talks about the same information. So how is it confidential?
Right, exactly.
Also, how is this conduct prohibited? Did she call the police? Did they do it? Did they arrest him? Like, how is this enforced? She's making a claim, but there's no substance behind it. There's no action.
My question on cross-examination for this is, Miss Owens, you attempted to try to have this proceeding go completely on papers for the stated reason that you were so terrified of Mr. Maricini. Why then does your declaration say that you watched a 2.5-hour YouTube interview with this individual as the main person speaking
about the harassment
you suffered?
Okay. Right. How was that not traumatizing?
Chocolate.
Chocolate.
I don't know.
Give the officer some chocolate, honey.
You know?
Respondent's 2.5-hour YouTube interview, in which he denied court-validated findings, disclosed petitioner's mental health history, and mocked her allegations, falls squarely within this prohibited conduct. That the abuse was committed publicly for the purpose of humiliating petitioner to a wide audience provides further good cause for this court to decline live testimony, because doing so will limit Mr. Maricini's ability to further abuse the legal system by harassing and attacking petitioner.
It's always like about her, right? Like he's not doing an interview to tell his story or to work through things with the people interviewing him. It's about her. It's never about him or the process he's going through.
He doesn't care about you.
Because she can't understand that something might not be about her.
Right.
What do they call it? Main character syndrome?
Mm-hmm. A third and final reason exists for this court to refuse live testimony, because respondent is an active member in a cult-like organization called Justice for Clayton, or JFC, which has been ruthlessly harassing and attacking petitioner, her family, and her attorney for over 2 years. No? She didn't come out until September of 2023. So I don't think it's September yet. Is it?
What is cult like? Is that like Barry's boot camp? Is that cult like?
We don't know.
Chick-fil-A.
There's a lot
people?
of vague stuff here. Like what does cult like mean? What is attacking? Attacking like with a sword, like in a video game? Like what does it mean? It doesn't mean anything. Like she makes these meaningless claims.
Yeah.
Following the filing of petitioner's paternity case against the former Bachelor star Clayton Echard in 2023, Justice for Clayton emerged as a group devoted to retaliating against petitioner and doing everything possible to destroy her. Though the JFC group was formed initially to support Mr. Echard, the respondent in Arizona paternity action and the Arizona paternity action filed by petitioner, JFC members have actively inserted themselves into matters unrelated to the case, including this proceeding. How is this unrelated? It's like directly related. Are you muted? Oh no, there you go.
I agree. And I don't know. Yeah, it's very weird. It's like inserted. Like, okay, if I go get a court document that's publicly available, I'm not inserting myself.
Right. And then you're covering a public case. If you do a video on it, you're covering a public case. You're providing commentary on a public case.
And I'm pretty sure the string of events was, we found out about Clayton, and then we found out there was probably more than just Clayton. And then we were like, oh shit, there might be even more than that. And no. Then no. We always knew about the TEDx talk, and we had kind of just assumed, wow, maybe that is her story. But then we were like, wait, let's double click. And then we were like, no, okay, this is actually different.
I mean, well, it unrolled in 2 vectors live, right? Because the first step was the paternity case with Clayton. And then we realized, hey, were there other, fake twin stories here with other men? Oh my gosh, maybe there are. Then suddenly,
we were like, she was in San Francisco before now.
Yeah, she's getting an order of protection against Clayton, and then it's like, wait, she has orders of protection against these other men also.
Right.
So
we saw the patterns.
There's 2 different patterns here. There's the pregnancy pattern and the order of protection pattern. So it's not just unrelated. It's related in multiple ways.
Right. And Mike was a witness in that case, and the judge ruled that there was a similar, if not identical, pattern of behavior, which included her behavior with Mike Maricini.
Yeah. And it truly ended up just being a coincidence. Actually, no, it didn't end up being a coincidence. She dragged this on so long that the appeal of Clayton's case just so happened to bump up next to the renewal of the restraining order.
Right.
So it was just like sort of a dominant, it was like a natural progression of events. It just was a news cycle.
And she went public. If she hadn't posted on Reddit, if she hadn't gone to the Sun, I don't even know. I mean, we would not be here right now in the same capacity that we are. I just don't think that we would.
Yeah, absolutely.
Because who knows
if
Clayton
tats,
would have
Lauren.
talked about it.
I didn't know you had that many tats.
Oh, I have like 15 or something.
I thought you said cats.
15
I only
cats.
have 14 cats. No, I'm just kidding. I don't have any cats. I have a lot of tattoos though.
Oh, a third and final reason exists for this court to refuse live testimony. Because respondent is an active member in a cult-like organization called Justice for Clayton, orgy. Okay. Following the filing of petitioner's paternity case, I realized I read that already.
Yeah, we gotta go
I
down.
thought you said something else. Anyways,
sorry.
Further.
Did you? Oh, you're messing with me now.
No, I didn't. I just read what's on the page.
We're gonna talk about this later.
I don't know what did I say?
Go ahead.
Oh,
say insert again.
Insert here. Following filing a petitioner's paternity case against former Bachelor star, emerges a group retaliating against everything petitioner is and doing everything possible to destroy her. Right through the JFC group was formed initially to support him. JFC members have actively inserted themselves. Sorry, I just reread all of that. Among other things, the JFC
Stop saying
group
inserting.
The following insertion obtained and widely disseminated petitioner's July 9th, 2025 DVRO renewal filing on social media within 24 hours of its submission to the court. Oh my God. Triggering a new wave of targeted harassment and online ridicule against petitioner.
How is this targeted harassment saying that Megan Fox is saying she's going to read a public court filing?
Right.
Nobody's contacting Laura.
No.
Nobody's harassing Laura. Nobody's contacting her.
Right.
Following her. Telling her things.
Yep.
I blocked her on Twitter. Like,
yeah, I mean...
like, what is the problem? I leave her alone. I don't talk to her. I talk about her, but that's allowed. I don't talk to her. I don't, try to send her anything message-wise or anything like that.
I've never attempted to.
I've never spoken to this lady, and she's relentlessly harassed me with false reports of me disseminating false medical diagnoses online. I'm like, lady, all I said is you don't have autism because you don't have autism. Like, I don't know what you're talking about. So
we've never seen diagnostic details behind that. So there's zero evidence.
And if she had it, like you have seen when she feels confident that like she is right, she will post a screenshot. Like she will post her evidence. She'll be like, no, you guys think this? Well, actually, this is what happened. You thought that Dubai trip was on this day? Well, look at this.
Yeah.
And like very much like that. Well, what about
Can I give you the password to my patient portal so you can see my 102 HCG result? I'll give you the password.
A medical history screenshot is not going to do it at this point. When you get diagnosed formally with autism spectrum disorder, especially later in life, because I just had that happen to me like 6 months ago. Okay. You have to get tested. It takes time. You have to go see a doctor, and usually in person. If I see a screenshot of her going to a telehealth provider and saying I have autism and they put it on her history, I don't fucking buy it.
Yep. And that's your prerogative.
Right.
I'm
not allowed to say that. It's targeted harassment.
Lauren, are there any like types of standards that like regarding telehealth and like its limitations on diagnostic viability?
So
there should be.
These days, it's a lot more lax than it was, especially after COVID. But you do have to follow up in person with certain conditions to get certain medications. I want to say it's like 6 months or a year. I'm not positive. I can't remember because I go to the doctor in person to get those meds when I need them. So it's like you have to be seen in person a certain number of times per year, and you can do telehealth in the meantime. Like you do your follow-ups that way.
She's Adobeing like all of this documentation right now.
Good luck with that, Laura.
Yeah, I mean they need to catch up on that because it's just not. Telehealth just something different about it,
Yeah.
Yeah. Mannerisms, body language.
I mean, I'm
not wearing pants right now. Y'all don't even know.
I mean, I
did
do
now.
I assume. No,
I can prescribe
think,
edibles from my tech van.
I'm sitting here naked.
Oh boy. That's a prescription for something.
I'm scared.
All I'm thinking about is what would Omar's response to that be?
Oh yeah.
Omar's so busy. I miss Omar. Man, he's been working hard.
Yeah.
People keep messaging me on Instagram. They're like, Lauren, what happened to Omar? I'm like, Omar's working. Stop asking. I miss him too. Stop asking.
He also he told me that his Instagram is gone because he's just not a social media guy and he was spending too much time on it. So
if you're spending too much time on it, you might be kind of a social media guy. But
it's got to meet those Q3 numbers.
Yeah. All right. Anyways, what were we talking about? We were talking about. Hang on. Patrick said something about telehealth. With certain diagnoses, right, like autism or ADHD or something like that, you should have to be seen in person. That testing should have to happen in person. I know a lot of people will not be favorable of that because it is sometimes hard to access for some people. But the fact of the matter is, diagnosing something like that over telehealth, it's not going to be the same. It's not going to be as accurate. You're not going to get as good of a read. I don't believe in that. I think that you should have to see someone with the professional experience and schooling to diagnose that eye to eye in person, so they can see all the ways that you're like sometimes it manifests in your body movements, something like that. It's not always just your thoughts. It's sometimes your eye contact or lack thereof, which is something that's a little bit easier or different over a computer. So it's something that I don't think that you should do over telehealth. Whether or not anyone's willing to do it, I couldn't really tell you.
Yeah, because I mean, you can see a broken arm, but you can't see, like an ovarian cyst. Although I'm sure they will diagnose an ovarian cyst over telehealth.
Yeah. Yeah, just to say, I'm having pain on my right side. It happens at these times, and blah blah blah. This is what the pain feels like. You could even Google it and tell them the exact symptoms that like Mayo Clinic says are for an ovarian cyst.
Yeah,
and then they'll say you have it.
Right. Okay, where are we at here?
Top of 10.
It's hard to see because I don't know if people could see that screenshot before, but it was just the one that says, now I'm going to read it. Come at me, bro. Let's go. I said I was going to do it too, and then I forgot because I got sick and all that shit, but I still will. Don't worry.
Don't worry. Members of the group referred to the Maricini DVRO as phony and falsely cast respondent as the victim, despite having no personal knowledge of the underlying facts or incidents that led to the issuance of the original order in 2018. Hey, here's that chat GPT hyphen. Well before the group's formation in 2023.
I know what you mean. I know what you're talking about. Sorry, that was exciting for me.
It's the big long one with no space on either side.
Yeah. Okay.
It's just no room.
Respondent
Look at all of them. Oh my god.
Yeah,
those
it's
aren't
all
even
over.
M dashes. Those are like
exactly.
That's
exactly how ChatGPT does it. Why would I know? Respondent has seized on this ignorance and worked exhaustively to frame himself as emotionally fragile and unfairly targeted, using sympathetic narratives to invite public support and cast Petitioner as the aggressor. Well, you were. One such narrative centers on a man he repeatedly described as his dying fucking bitch.
Wait, what?
During the course of the relationship, a claim designed to evoke sympathy and humanize him on the online audience. In truth, this individual was his mother's former boyfriend, not a legal or familial stepfather, and even respondent acknowledged the relationship's hollowness? Writing that.
I don't think this quote does what she thinks it
does.
God, you're a cunt. What a cunt.
Oh my god. Oh my god.
So
wow. I haven't read this whole thing yet.
He died and Mike had to go through it, and she's throwing him under the bus here to try and discredit him. This is terrible. This is terrible.
This doesn't have anything to do with anything. There's absolutely no reason to do this.
Actually makes my blood boil.
Yeah, I know. I feel a little. I'm feeling some things.
Yeah, I got it.
Okay. This selective and misleading framing is emblematic of respondent's broader strategy of narrative manipulation, presenting himself as a wounded party to distract from a judicial record that does not support that claim. The Justice for Clayton group has seized upon these distortions, amplifying them as a fact and using them as justification to vilify and harass Petitioner across multiple platforms.
Fuck you, you blood-sucking fucking cunt. Common sense has eluded you for your entire life, but it's fully on display here. What is going on? Like, why would you say this shit? This is terrible, and it just shows that you're harassing him.
I think that when you talk about Darvo and reversing the reversal, there's a lot of that going on here, because I think her mindset is she's either this heroic figure doing TEDx talks, businesses, horse stuff, or she's a victim all the time. So she can't handle him actually coming out and telling his story as being the victim, because it takes away from her victim story. So she has to reverse the claims.
Yep.
Does that make sense?
Yes.
I don't think I'm explaining it well.
And is she claiming this is under the factors that she enumerated on page 6? Is this a material fact that's in controversy? Is this testimony that's necessary to assess the credibility of the party? Like, this is not related to anything. I would move to strike this. That's disgusting.
My take is that this is her attempt at going after credibility, but it's coming from this place of projection.
Well, you know what? If she wants to go there, and he does have the 2,500 pages, let's fucking look at your credibility, Laura. I think there's a whole lot of probably a couple thousand pages in there that would refute your credibility.
Yeah.
We just need one page. 7 felony indictments.
Right, exactly. Just look at this. Organized in-person attendance at Petitioner's Arizona court hearing in June 2024 were more than
people
50.
A court hearing with people.
That's a public court hearing.
It was a celebrity, technically, court hearing. And David said at some point, didn't he say it was like over 1,000 at some point? Like something ridiculous like that?
Oh, I don't remember.
David said some stupid shit like that.
50. That's all? 50? Should I write
people?
about that?
You think all those security guards couldn't handle 50
That says
of us?
more than 50. I mean,
so the
51.
The first 2 factors she dedicates 3 pages to. The third factor, which is he's part of a cult, it gets 3 pages in and of itself. So it's just rambling. And I don't see them as coherently connected to any one of the factors.
No.
I think the correlation is what upsets her the most emotionally. That's where she's spending the most time in this document.
Yes.
Yeah.
I mean, that's exactly the right analysis there, which is not part of the factors. I don't see any of these factors how hurt my feelings are. That I got caught lying over and over and over again.
And that I put myself in this position because I went public.
Why I look really bad. Not a factor.
Oh my God. Already begun organizing in-person support for respondent at the August 1st, 2025 hearing in San Francisco.
Where though? I didn't actually see that. I'm not saying it didn't happen. Where though?
I have not seen that.
I haven't either. God.
More claims without evidence.
What? Shocking. JFC operates a network of social media and internet resources devoted solely to attacking and harassing Petitioner. These pages include a primary Instagram account located at blah, 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 a Twitter account located at blank, and various websites which are blank and blank. Shortly after the renewal petition, so she's directing them all to all the information on her.
Why does it have to be a primary Instagram account? It can't just be an Instagram account? I don't understand.
Right.
Why is the word primary there? Also, is she sort of claiming that like the same person runs all of these sites? Because there's no evidence of that.
No.
I would be very surprised if the exact same person operated all these sites.
That would be a whole hell of a lot for one person to do. They not have a life, a family, or a job.
Yeah.
Or
doesn't
life.
make sense.
Shortly after the renewal petition was filed in this matter, JFC's primary Instagram account began posting solicitations for coverage of this matter by local San Francisco news media, as well as inviting members of the general public to attend. These posts falsely state that this court is allowing media outlets to broadcast and photograph the hearing.
What do these screenshots say? We need you to cover the new Laura Owens. I mean, they can cover the case. That's a normal thing, right?
Mm-hmm.
Yeah. I mean, I don't see anything really wrong with this. Members of the public can attend. Okay. That's true, right?
Yeah, which part is false?
Right.
Mm-hmm.
I'm confused.
This isn't like organizing. It's just public information. It's just sharing public information. It's not like saying, we're going to meet at the Starbucks on this street corner and we're going to march over together. Like, this is ridiculous.
And it says they can attend. It doesn't say you must attend.
You must attend in your cult uniforms.
Exactly.
I'll buy you a Starbucks, Lauren.
Yeah, okay. Yeah, all right. So this was, when was this? The hearing will be rescheduled. When was this post?
I don't know. But whoever runs that account can look at all their viewers and see she obviously viewed this, unless she has like a friend who viewed it.
I would say block the questionable ones, yeah.
Mm-hmm.
I mean, I'm sure they do. All right, anyways, moving on.
Do you want me to keep going?
Yeah.
Respondent's sister, Stephanie, who regularly posts on Reddit under the handle Redacted, continues to engage in targeted harassment against Petitioner and her family. Following respondent's June 2024 interview with the content creator Megan Fox, Miss Blank publicly applauded her brother, writing, "I'm so grateful that your demeanor, truth, authenticity, and kindness are finally seen, and you're no longer silenced by manipulation and fear."
Well, that's clear
what's
harassment.
Wrong with that?
Clearly harassing behavior. Oh my god.
It doesn't even mention Laura.
No, it doesn't.
This was more than a swipe at Petitioner. It was a brazen misrepresentation of legal reality.
You want to talk about misrepresentations of reality with me right now? You stupid bitch. Do not. Oh.
It's like she spends all her time manipulating systems so that there's some sort of written record that vaguely asserts something she wants, a point she wants to make. And then she extrapolates off that.
Yes.
And I mean, like, the court system does not define reality. Okay. We create models that help us predict how reality behaves. That's called science. The court system is not for defining reality.
Right.
There's no one else in the room right now except for me and Patrick's dog. I'm sorry.
Yep. Oh, cute. Is that a Papillon?
He is a long-haired Chihuahua.
Oh, okay.
He had a dental procedure yesterday, so he's high as a kite.
Oh. Hi.
And then the lab is over here. She's right there.
Aww. Oh, they're like same colors.
Oh yeah.
That's cool. Cute. Aww.
I'll leave Messy on screen.
Yes, please.
It'll make this easier to read, maybe a little bit.
Something needs to, because wow.
Neither the San Francisco Superior Court nor any other court modified the standing DVRO to permit respondent to speak freely about the protected party. Yet both respondent and his sister acted as, what the fuck did she have to do with it? Acted as though the order had been lifted, weaponizing that false narrative to cast Petitioner as a manipulative oppressor. You are. And respondent as a silenced truth teller. He is. This deliberate distortion not only undermines the authority of the court, but emboldens further harassment by suggesting that the court-ordered protections no longer carry weight.
Huh?
I think we just broke Lauren.
Somebody says, somebody did. Somebody says Lauren wears butter. So my sister moved in with my parents for a little bit, and so my dog is staying there with her dog while she's still living there. So that's where he is. Nice. Yes, you definitely just broke me, because that's the dumbest thing I've ever heard. This deliberate distortion not only undermines the authority. I'm sorry, I had to read that again just to make sure it was as stupid as I thought it was the first time.
There's kind of two things going on here. One is she's always making these claims that people are violating these orders. We've seen these police calls and all this stuff, and it never washes out. Like, people don't get arrested. You know, there's never any proof or conclusionary action that demonstrates that an order was violated. That's the first part. The other part is this more emotional, or this, you know, the PR part of it, where it's like, okay, the petitioner is a manipulative oppressor and the respondent is a silenced truth teller. She's just telling on herself at this point. Like, yeah,
Right.
that's what people think. If you want to convince them that that's not true, you have to do it with good arguments and good evidence.
Real evidence.
You can't just say it's wrong. Like, you have to convince me it's wrong.
And isn't the order just that he can't say anything harassing or to incite other people to harass her? So by stating an opinion that is not either of those things, it kind of reads like she wanted to say, and the court should send Mike's sister to jail, and Jingers is like, let me just try to wordsmith this a little bit.
Or ChatGPT's like, yeah, I don't think that doesn't quite fit within the lines of the law here.
Honestly, the only AI that's gonna write this is Brock. Like, ChatGPT would be like, y'all, you are lying.
I don't know. She continuously conflates somebody talking about her or their experiences with her, and she conflates that with talking to her. No one is
harassing
talking
her.
to her. Yeah.
We don't want to talk to you. Go away. I know you're watching this. Go away.
Period. End of story.
I don't have anything else to add. Just go
and
away.
she doesn't mean forever.
No, I don't want you to die. I just want you to go away, preferably to jail. You know what I mean? So that'd be good.
Or Ohio.
Ohio? Why?
Isn't that what the kids say? I don't know.
I don't know.
I don't know any kids.
I think she and Jingris should get married and like move to Jamaica and just have like a fabulous life together.
Ew, your scenario is not what I want for them. Ew.
What? Then they'll just have each other and they'll stop bothering other people.
Why don't they just have each other's, you know?
I did not subscribe
I don't know.
to this fanfic. I don't know.
And if they're happy, then maybe they'll stop trying to hurt other people.
You know that's not going to happen. They're just going to do it together like they are now.
Well, maybe they'll do it to each other then and leave everyone else out of it.
In Ohio.
Laura, I want Laura to be happy. I want her to find happiness and move past all of this stuff that she's done and like pay your dues, spend your time in prison and pay all the legal fees and fees to Clayton and all that shit that you have to pay. And then like work on finding happiness in your life. Because I think like they say hurt people. I think it's a dumb saying, but I think it's true. And so if she's not feeling that way anymore, then maybe she won't continue to hurt people.
Look, man.
This would be the adult responsible thing to do. But we
haven't I'm just not convinced.
We haven't seen evidence that she wants to do.
I'm not saying I think she'll do that, but I hope that for her. I would hope that's what she could achieve.
Yeah. We have dreams. Because if you don't have dreams, all you have are nightmares.
But the walls are really closing in on her. So, I mean, this may end up just being her identity.
I think it is. I think this is going to be what it is for the rest of her life, to be honest. I think that she's so used to this toxic cycle that that's all there is for her. And that when she does go to jail and get out, she's going to do like a whole book deal and double down on all her shit and try to paint herself as the innocent victim of all these men. And I think she's continue that for the rest of her life.
She's signed on to whatever project or projects come of what's being made.
Right. And I'm sure she's going to assert her innocence there, which is absolute bullshit. But
can you imagine that
go.
next to everyone else's accounts of everything?
I can imagine she would do that next to everyone's accounts. Yes.
Wow.
No, I'm just saying, like, as a listener who's never heard this story, hearing her and then hear all these other people talk about their experiences.
Right. Yeah. And there's going to be some crazy people out there who are like die-hard stands for like Amber Heard and shit like that. Who are going to be like, oh, Laura Owens is innocent. No, she's fucking not. But there's going to be people like that.
Can we find one of them and interview them? Because I would like to talk.
I'll let you know when we do.
I have an open invitation to Dr. Midchill and any of these people that think she's correct.
Bruce, if you want a crazy person to go on your show, I'm available like every night.
No, I mean, well, you don't think she's correct. You don't think she had the twins. Or
no,
whatever.
Sorry. I just thought you were looking for a psycho.
No, I'm not writing your Tinder profile or what. I don't know.
I thought we agreed that you would, but that's,
Oh.
You always disappoint me.
I got to meet my Q3 numbers. I got to get on that.
Mm-hmm. Yeah. All right. Where were we?
Most recently, I believe.
Okay.
Most recently in June 2025, Miss Blank commented on a Reddit thread discussing a credit card lawsuit filed by JP Morgan Chase against Petitioner's elderly parents who have been struggling financially. Petitioner's father, who is 79 years old, has 133 types of cancer and has had Parkinson's for 120 years. Has lived with Parkinson's disease for 24 years and has survived 4 separate battles with cancer. Despite this, Ms. Blank publicly mocked the situation, writing, JP Morgan, you rock. Get this pathetic criminal family to pay their bills.
What does that have to do with his cancer?
Right. It
has nothing to do with the diseases.
It's getting real for these tools.
Is it established knowledge that this redacted person is the same as the I think it was a Reddit account that was named?
I believe this is all the same person who's been mentioned from the beginning.
Is it? Okay.
But I mean, is the person and the Reddit account the same or not? Because we've seen in other filings, she'll say, here's a Discord account or something. And I think it's so-and-so. And
right.
like,
I have I didn't see her present any evidence or say that she said anything that like implied that like I'm your sister or you're my brother. Also, I could get on there and make an account and say that I'm his sister.
Yeah, that's true. It would have to be the redacted person, saying, "Hey, I'm so and so, and this is my Reddit account."
Right.
And you're correct. They could be lying. So we don't even know. But I'm just asking
yet another
if there's even that. Do we even have that?
Right.
Probably not.
I mean, I didn't see it here.
In the OG subreddit that got taken down, someone convinced her that they said they had talked to her and that she admitted everything, and then like had a completely like then she started like being like, no, you didn't tell me. I didn't tell you any of that. And they're like, yeah, you did. And she was like, no, it literally went on for like over a day of her just being like defending that she didn't say something that this other person clearly knew she didn't say. Mm-hmm. So I wish those weren't lost to time, but like her delusion, this is pretty par for the course. It's not even that much.
Right. Yeah, there's no evidence yet. Reddit has not been subpoenaed and like, shared the identity of that user.
Yeah. So these are all just allegations made under the penalty of perjury. So I mean, I guess she can have she has to have a good faith belief, but that good faith belief would be subject to cross. And then all of these things are just things that are subject to cross that if she doesn't have a convincing response to, the judge is going to take a negative inference from in terms of credibility.
Mm-hmm.
That's exactly what happened in the Clayton case.
Mm-hmm.
Yeah, it's too many words.
Yeah, for sure. Okay. Reflecting a cruel level of further underscores the vindictive and harmful nature of the harassment tied to the respondent's support network. These cumulative actions coordinated online attacks, public dissemination of confidential findings, personal humiliation of Petitioner and her family, and planned in-person confrontations create real and immediate risk of re-traumatization and psychological harm to should petitioner be required to testify live. The protective intent of California's Domestic Violence Prevention Act would be completely undermined by forcing a survivor.
You're not a survivor, you dumb cunt.
Mike is the survivor.
Right.
And he would be forced, he's forced like every day to have to like live under this phony order of DVRO that you filed against him. Survivor to confront both their abuser and his coordinated support network in a live public forum, especially when there is no legitimate reason for doing so.
Imagine characterizing the United States judicial system, which is funded by the public and has the public's ability to go to court and watch a hearing in person, and to characterize that right as planned in-person confrontation. Mm-hmm. This is very authoritarian language. Mm-hmm. This is not the ideals of the United States of America in this language.
It's very Trumpy to me. Like I could see Donald Trump making these complaints.
I mean, whatever authoritarian analogy.
Well, that is the one. I won't go into it further, but that's the one it makes me think of.
I mean, it just doesn't strike me as good.
Yeah. All right. We're getting to the medical necessity and ADA accommodation. So I don't want to get too much into this. I want to skim over a lot of this stuff. So let's see. So she's saying that she submits her medical diagnoses are supported by verified treatment records and clinical assessments from multiple licensed medical providers. We know that, including her psychiatrist at Spark Shift Psychiatry, neurology specialist at Barrow. And we know like these are people that she doesn't really have to see. Mm-hmm. Spark Shift Psychiatry, I also believe, is telehealth as far as I'm aware.
Sounds like it.
Yep. And so that is in line with her same strategy of seeing telehealth providers and telling them this is part of my history, and they just write it down. Mm-hmm. That, or she found someone who would diagnose a condition that most people are not willing to diagnose unless it's in person. So she's listing her medical conditions here. I'm not going to, go too much into it if she like gives a lot of details, but she says the autism again, which I firmly don't believe that she has. You guys know that. The TBI is mentioned, the epilepsy is mentioned. We don't really know if she either has either one of those things. If it was probably from falling off of a horse, probably. Mm-hmm. PTSD, again, I don't really believe she has that. Panic disorder, I mean, she might have that. I would panic a lot too if I lied for my entire life and I had to protect that false narrative constantly. You know what I mean? Mm-hmm. I would have a lot of anxiety. Most recently and most urgently, Petitioner was recently diagnosed.
Really quick, though, let me ask you this. If we look at that list, and we've seen an even longer list, I think, on the Instagram account, and it says in there that there may be more things. In your experience, is it common for all these things to happen
to one person?
Or is this an outlier, or what's your experience there?
Sorry, guys. Thanks to the Flux Raiders, by the way, for joining us. So you want to know if it's common for all these diagnoses and stuff to go
for one person?
Well, yeah. I mean, how realistic is it for one person to have all these things at the same time? Like, do you see that a lot? Do these things go together? Is this normal or natural or common? Is it very rare? Is it? I mean,
this combination of things, this specific combination of things is common to be like co-occurring, like epilepsy, PTSD, TBI, panic disorder, and GAD. That is common in like soldiers, people who have been to war and have come back with injuries and stuff like that. Mm-hmm. That's not so, but that's in a specific context, right? Sure. And I'm not saying it's impossible, because people who have been battered spouses and such, like, yes, you can still have these co-occurring problems, but what she's describing in the evidence that we've seen, and so I have to think about her specific case. Like, it doesn't make sense that she would have all these things co-occurring, especially when she has given like here and there different statements regarding different symptoms that contradict each other, don't make sense. Nobody's ever really seen and done a formal examination of any kind to diagnose these things that we know of. She asserts that she has these things based on like these vague medical documents that basically just list it in her history. So I don't know if you are like just like a regular everyday person to have all of these things co-occurring. It's not impossible. I don't want to say it's impossible, because you do see that in, like I said, soldiers and battered spouses and stuff like that. But it's a lot. It's a lot.
Yeah.
But at the same time, I'm not going to say that it's totally outlandish. It's not outlandish.
I think the problem I have is that my trust level is very low just because of all the things we've seen in terms of the history of these cases. The thing you mentioned, which I would call sort of like manufactured evidence, right? You call someone up and say, hey, by the way, I'm pregnant. They write down the person's pregnant. Now you have a piece of paper that says you're pregnant. Oh, I have proof. Right. It's circular reasoning, right? So it's manufactured evidence, circular reasoning. These other things where the evidence just isn't good enough, right? Because this is a lot of claims. So the standard of evidence has to be very high, right? It's not just a mundane claim. Like, oh, I get headaches every now and then. It's pretty mundane, right?
Right. Let's see. So most urgently, Petitioner was recently diagnosed with this most severe category of anorexia nervosa, binge eating / purging type. The most critical classification under the current diagnostic framework. Why are you trying to... Okay, I feel like she's trying to make it seem like it's the worst possible ever, and she's going to demonstrate that somehow as like a reason to seal her case. As of July 17th, she weighs 83.3 pounds, which is insane, by the way. That's insane.
She's going to the gym 1 to 2 times a day.
Right, which is nuts. You should not be doing that.
If I'm sure her doctor wouldn't even be recommending for her to go to the gym. That would be unsafe. And if she says susceptibility to cardiac arrhythmia, hypotension, loss of consciousness, organ failure, significant cognitive impairment,
nobody's going to recommend going to a workout. Yeah. That's nuts.
Could the gym even... I mean, the gym could be liable, honestly.
Exactly.
Yeah, for letting her...
Nobody's going to recommend that.
Yeah.
Let's see. So she's saying here exactly the conditions she would be subjected to in a live courtroom hearing, particularly one involving her former abuser and a gallery of observers affiliated with the coordinated online harassment group. And I'm sorry to say it, because if this were any regular woman who was saying she had these problems, I would never question it right away. I would never say anything like that. I would automatically just be on the side of this person is telling me they have these problems and I want to believe what they're saying. I have no reason not to. But this is Laura. And I don't believe that she's really, I don't believe that she's not milking this for all it's worth. And I hate to say it. I do, because it sounds terrible. But we know that she manipulated her weight when she was in the middle of her case with Clayton. So
she gained weight leading up to that. She was seen exercising excessively after that. And then at the size she was at the hearing.
Yeah,
I think it's context,
and in
right?
the December video of the FBI call to her place.
I think it's context. If someone says, hey, I have health problems, I need help me, we're going to help them. But if somebody says, hey, I have health problems, and this is why you should just give me a fast path to get a lifetime DVRO against another person, that's a different story, right? So the context is very important.
Jane says, I had anorexia. I weighed 74 pounds and was hospitalized several times because of a lot of things you're mentioning. I wasn't allowed to work out. I had to sneak to get a walk in. So yeah, it's not like people are letting you go to Barry's boot camp twice a day.
And congratulating you on how many classes you've taken.
Especially if you're susceptible to cardiac arrhythmia. If you're like losing consciousness and having cognitive impairments, nobody's going to be like, yeah, work out harder, keep coming back twice a day.
And didn't she get her trainer certificate? Physical trainer certificate?
Yeah, when was that? I can't remember.
Months ago. But still, I mean, it was after the trial where she weighed, what did they say she weighed there? 91 pounds? I can't remember.
Something like that, yeah. Petitioner has been the repeated target of vicious public ridicule and body shaming by the online harassment group known as Justice for Clayton, JFC, which has openly aligned itself with respondent and amplified his narrative through coordinated defamation, targeted memes isn't a court filing, and monetized outrage. Members of this group have referred to Petitioner as a horse-faced anorexic, mocked her weight and medical diagnoses. Well, your medical diagnoses aren't real. And disseminated dehumanizing content across Discord, YouTube, and Reddit. These are all things that you do not have to be a part of. You seek them out. And as much as like it might suck when people make fun of your looks and stuff like that, because I'm experiencing that like increasingly often these days, it sucks. But you don't have to go to these platforms. That is on you to avoid those things. You cannot control other people and what they say, even when it's very rude, even when it's very hurtful. You have to like be responsible for yourself and just say, I'm not going to visit that website. I'm not going to watch this video. I'm not going to post in this thread. You got to.
This isn't amplifying his narrative. Tell me where he said these things about her.
Right. Exactly. A widely circulated meme dated June 14th, 2025 exemplifies the kind of viral cruelty Petitioner routinely endorses. And that's like the Momo doll or something. There's not even any text context with this.
What does widely circulated mean?
People in the Discord saw it, which is like not a lot.
Yeah, I mean, it's a qualitative.
Right.
It's not a quantitative. I can't go verify that something was widely circulated because it doesn't mean anything. There's nothing here to test it against. Mm-hmm. Also, we have a quote here, the quoted mocking. There's no citation there either, so we don't even know if that's what somebody said or not.
Right. Among the many JFC affiliates, here we go. Okay. Content creator Lauren Neidigh warrants particular attention. Thank you, Laura. That's sweet. Not because she's the most popular or lucrative. Wow. Thanks for telling everyone. But because she is the only individual who formally petitioned this court for direct media access to the August 1st evidence you're hearing. Well, God forbid I go through the formal court process for making a media request.
Right.
She really mastered the art of the compliment sandwich. You have the compliment on both sides, and then you just put a dig right in the middle. And she's not the most popular or lucrative, but she did this and she did this other.
She's
thing.
negging me, man.
It's a good compliment sandwich.
I think she likes you.
Ooh. Yikes. I'm straight now. But because she is the only individual who formally petitioned this court for direct media access to the hearing, despite lacking any professional journalistic credentials or affiliation. Okay, guess what, baby? This isn't McDonald's. I don't need a badge on my shirt to be a journalist, okay? That's not how this works. There is no formal body, governmental body for journalism. I don't have to have credentials.
Oh my God, wait, let's ask
to work for a news
J.J.
outlet.
Jones.
Yeah, right? Go fuck yourself, okay? That is not how this works. As you know, because I was at your last hearing, which you were a bitch at too. Ms. Neidigh submitted a formal media request to permit coverage, which was denied by the judge. Okay, cool. And like I said to Schnitzel Ninja, I don't know if I said this to anyone else, I didn't even tell anyone when that was rejected. I was like, okay, I understand that those are just the type of hearings that might not allow footage in that because it's a really sensitive subject when it comes to like DV and stuff like that. So
for people who are telling the truth.
Right. So I was just kind of like, you know what, whatever, that's fine. I didn't think twice about it. I didn't tell anyone about it until this showed up on the docket under Laura's name, which confused everybody. And then it showed up and it was me. And I was like, well, no one told me they were going to tell me like that, but it doesn't matter because I didn't really have a problem with it. I was just kind of like, okay. And then I moved on immediately. Mm-hmm. It did not cross my mind again.
Mm-hmm. I really found the Barry's boot camp waiver, by the way.
Oh man. Oh man.
In order to sign up for any Barry's boot camp, you warrant that you are in excellent physical condition. If you are injured, ill, or recovering from injury or illness, you must notify the instructor.
Oh, wow. So they need to be subpoenaed and asked if they were ever notified that she has anorexia.
Right. Or
waiver violations.
Or she's actually, or you could say, actually, what she said in this pleading is a lie because she warranted that she was in excellent physical condition.
Right, because she signed this, obviously, to exercise there.
Well, she's either violating the waiver or being incorrect in this filing.
Right. So which one is it? Does she care about Barry's boot camp more or Mike? Like that's the final battle right there.
She really seems obsessed with these irrelevant veneer of accreditation or something, like titles, resumes, right? Nothing of substance, right? It's all about, her parents, the accolades you would put on LinkedIn or something, right? Like, it doesn't matter if you are paid by NBC to be a journalist, right? Like, why does that matter?
It doesn't.
She doesn't explain why it matters. She simply uses it as a weapon to throw people under the bus, right?
Mm-hmm.
God, I wish I had credentials from medium.com, Laura.
I know.
This is retarded. All right, anyways. Within 24 hours of that denial, Miss Neidigh, thank you for spelling my name right, I guess, retaliated. Okay, she retaliated. I retaliated, apparently, even though I didn't tell anyone about it and was visibly not upset about it because I was thinking about other things that are way more important than Laura. By releasing a monetized YouTube video titled "Con Artist Laura Owens Crashes Out and Wants Her Victim Prosecuted." Okay. The reason I released that monetized video, Laura, at that time is because that's when the documents came out. Who said anything about retaliation? I don't think I even mentioned the court thing. I did not even mention the request. Like, so like, what are you talking about retaliated? I would love for you to show your work there. But, you know, if you want a better screenshot than the one below, hold on. Here. Nope, that's Patrick. No, this is actually hilarious. I like this better. No, hang on. How do I make it? There we go. Here.
I was like, oh, what's she gonna do?
Oh, there I am.
What is happening?
It's twins.
I tried to share Barry's boot camp T's and C's on accident. Oh, okay. I can bring the dog back in. I think he's asleep though.
This is the Patrick show.
Oh, damn. Yeah. Yeah. Welcome to my Lego sanctuary. Thank you.
Hey, Lisa. Mona.
Who is Lisa? Oh. Okay.
Yeah, that thing was hard. Yeah. And then there's our Murphy bed because we live in a tiny ass condo. I think the dog is still here. Yeah, she's still there.
Aw.
Passed out.
Cute.
Where's the other one?
You just care about the little one.
Okay, well, the little one left, so you're off the screen.
Yeah, that's her. That's her. Actually, speaking of, I think I'm going to jet because it's almost midnight over here.
No problem. Oh, I'm over where you are, so I know.
Oh, yeah, right. Perfect. Yeah.
Right.
But it was great catching up with everyone. And I'll be on the lookout for more. Like, what do you think is coming next here? You know, are we going to, what do you have any predictions?
I don't.
I think probably maybe we're gonna hear something from Mike.
Well, yeah,
sometime soon.
Yeah, there was some chatter on the Reddit about, you know, like reservations about donating because he hadn't retained counsel yet. And like I definitely think everyone is entitled to their opinion. Like that's why it's the internet. But you know, given what was said in this pleading about criminal charges and wanting an investigation, like I mean, there's so much at stake for him that I think it's very reasonable for people to feel comfortable. Like if they're donating, the money is going to be used towards some type of legal defense.
Yes, 100%.
Yeah. So with all that said, my prediction, if I had to make a prediction, Laura's Barry boot camp membership gets canceled for violating the terms and conditions.
It should, dude.
Oh.
But I'll catch y'all later. It's great seeing everyone.
All right, thanks,
great seeing you too, man. It's been a while.
Have a good one.
I'll be back for sure.
Awesome.
Bye.
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 All right. Let's see. YouTube video in which she falsely claimed that the original restraining order was based on completely fabricated information. Where's the lie? And referred to respondent who has been subject to a valid DVRO since 2018 as one of Petitioner's victims. All right. On July 16th, 2025.
Your Honor, Lauren has opinions. Arrest her.
I mean, please do. I'm my God.
What the heck?
I'm primed for an Orange is the New Black scenario.
The public has opinions. That's how it is.
Yeah. She escalated her campaign. My campaign. Really. I barely talked about Laura much for like the last 7 months or so. But all right. My campaign. Escalated her campaign with another video entitled "Help Mike Maricini Fight His Abuser in Court." I stand by that. In which she again labeled Petitioner as the abuser. Laura Owens is the abuser. Laura Owens abused Michael Maricini. I will double down on that. all day long. And openly encourage her audience to donate to respondents' GoFundMe legal defense. Since when is a non-party to your litigation, or your, not litigation, but your case here, responsible to not encourage people to donate to something that might benefit one of the parties? Like, what are you talking about?
Where's the crime?
Right, exactly. That's not my best screenshot, to be honest. Okay.
It's kind of a cool lamp in the background.
I was in a hotel room in Arizona, man.
There you go.
Although Miss Neidigh is not the most widely followed or monetized figure profiting from this case, oh my God, I'm not? She is part of a much broader online ecosystem of content creators who have built a cottage industry around harassing, misrepresenting, and dehumanizing Petitioner for profit. Lady, I have never talked to you. I have never tried to talk to you, and I will never want to talk to you. I have never harassed you. Okay? I don't send you messages. I don't call you on the phone with the 13 Google phone numbers. That's not a thing. There's no harassment.
Harassing is wrong. Dehumanizing is kind of wrong. I mean, she's human.
Absolutely, she's human.
I mean, we assume she appears to be human. I don't have a problem with that. The human race. Yeah. She could be human. Misrepresenting. I mean, if she thinks somebody's saying something that's wrong, she should go back and refute exactly why. Like, if somebody was making a bunch of flat Earth videos, you don't just go to court and complain about them. You go make globe Earth videos and you say, look, the flat Earth guys are just wrong. Let me explain why they're wrong. She doesn't do that. She just makes declaratives.
So you bring up the flat Earth thing a lot to make your comparisons. And it's really funny because people in my comments will be like, did Bruce just compare Blake Lively supporters or something to flat Earthers? That's epic. And then I'm like, no, Bruce just says flat Earth all the time to make his point. That's just kind of like one of your go-to comparisons, which like it always makes sense. But
yeah, because like, no, I don't want to like ban or silence a flat earther. I just want to explain to them that they can go do the Eratosthenes well experiment themselves. Like, go do it. Absolutely, it's not hard.
All right, let's see. Okay. Collectively, these individuals have released thousands of monetized videos since 2023. I think thousands is probably exaggerating a lot. It's probably like, I want to say probably several hundred maybe, but thousands is too much.
She's saying everybody.
Yeah, right, together. Still, I think thousands is too much.
2,000.
Right, because she's saying that I have posted over 150. And if I've posted 150, which I posted a lot, then that means together we're probably not more than several hundred. So, because Dave's probably got more than me, but at the same time, Dave and I together probably have less than 1,000, much less than 1,000, like way less than 1,000.
Again, where's the Excel spreadsheet? I want to see the Excel spreadsheet go over 1,999.
Yeah,
show it.
Mocking petitioner's medical conditions. Okay, you don't have those medical conditions, so I'm not mocking your conditions. I'm mocking you for lying about it. Sharing private details of her legal proceedings. There are no private details of your legal proceedings to share. They were all public, 100%, as is this document.
That's weird.
Yeah, and promoting false narratives designed to incite hatred. Cite your sources there. What did I say that was false, designed to incite hatred? I mean, it's not my fault that people hate you for the things that are very 100% real that you did, that I talk about. That's not my problem. So, Miss Neidigh alone has posted over 150 such videos since May 2024. Like I said, that means there's definitely no way that together we have thousands, because I'm one of the people who posted the most about this case. So, no.
150 videos, Lauren. You should have made 200. Come on. Step it up.
She bored me.
Slacker.
She started boring me so much. Requiring petitioner to testify in person would only amplify the potential for further exploitation. Screen cap. You want to talk about screen captures? You just screen captured me, bitch. All right? Don't talk to me about screen captures and exploitation. All right. And viral mockery, serving no probative legal function, but inflicting profound emotional and medical harm. I feel like it's a pretty important legal function to have you testify.
Probative legal function. It's almost like she lives inside the legal system and the rest of the world doesn't exist or something. It's very weird. It goes back to this thing where she's like, the truth is defined by the court system. That's not true. The court system is a process to resolve dispute. It doesn't define reality. It's this fundamental problem between reality and science versus the legal system in America.
Petitioner's physical health is fragile. Okay. Well, that's something that you can choose to work on. I mean, her psychiatric condition acute. So this right here, psychiatric condition acute, is bullshit. Okay, acute is something that is in the moment, it's an emergent, and it's happening like very fast. It's sudden onset, and it's a heightened crisis compared to what you've had at your baseline. This lady has been starving herself, obviously, for years. Okay, I'm sorry. I don't care how she looks. I'm not, talking about her looks. I think everybody, like, their looks are the least important thing to me. So I'm not mocking her looks at all. But I'm saying this is not an acute problem. This is obviously a long-term problem. Exactly.
Yeah.
So don't misrepresent that as if you're in some sort of emergent condition, because you are at like this all the time. And if you're having an acute condition, you need to go to the hospital the way you used to pretend to and get some fucking help. And that is not the fault of Mike Maricini or anyone else involved. That is on you. Take care of your shit.
I think she used the word here without really understanding what it means.
Probably.
Mm-hmm.
So David probably did it for her. And the courtroom environment.
He's like, he was like, you're acute, Laura.
Oh, God, it hurts. Oh, no.
No.
Also, my internet went out, so I'm...
Oh,
that's why.
Okay. Particularly one populated by observers affiliated with an online harassment campaign. There's no smear campaigns, no harassment campaigns, guys. People just say shit about you don't like. Somebody needs to tell all the entitled women in this world, people are allowed to talk shit about you, even publicly. You do not have to respond. You do not have to listen. And you definitely don't have to drag them into your court documents. My God. All right. Poses an undeniable threat to her safety and well-being. Why? Because I made fun of you for being a cunt? That's a threat to your safety? I'm not going to hurt you. I've been in the courtroom with her before. I didn't talk to her. I didn't even look at her. Barely. You know what I mean? Unless she was like on the thing testifying. So that's ridiculous. It's not a safety threat. Somebody said something bad about me and they might be in the same room. Well, welcome to high school, bitch. Jesus. By contrast, written testimony would provide the court with the same factual record without endangering petitioner or enabling further abuse. Petitioner anticipates that respondent may attempt to discredit her medical records. Why would someone do that? That's awesome.
Don't give us any ideas. Oh my gosh.
Unsupported by evidence?
Jesus Christ.
Could she write some more motions and anticipate what else we could do?
Oh God. Oh God. Petitioner anticipates that respondent may attempt to discredit her medical. Can you just read this for me, please? Just you do.
Do I have to read this?
Someone else, please.
Petitioner anticipates the respondent may attempt to discredit her medical records by questioning their authenticity. However, any such claim would be entirely speculative and unsupported by evidence. Petitioner is fully prepared to authorize HIPAA-compliant releases. I think if you have medical records, you can just release them. You don't have to authorize anyway. And welcomes any lawful effort by respondent to verify the documentation directly with her licensed medical providers. Okay.
Here's my Banner Health login.
Oh boy. Absent such action, vague insinuations should carry no weight with the court. I think she doesn't understand the burden of proof. So she's released this list in this document of these medical conditions. She is making the claim. I'm not making the claim that she has or does not have these medical conditions. I'm making no claims. I'm neutral. Like, she might have these medical conditions and she may not. My answer is, I don't know. That's my initial starting state. She made the claim, so the burden of proof to prove those claims is on her. She is burden shifting by saying the petitioner will welcome lawful effort by the respondent to verify. No, you make the claim, you back it up. It's not the respondent's burden to verify your claims are correct. That's the end of the section, Lauren.
Oh, I'm broken. Okay. All right. We're almost done here. Request to seal. Petitioner respectfully moves to file this motion under seal in accordance with, and then I think Patrick had some stuff to say about this, which is unfortunate because he had to leave us before we got here because I was too busy talking a lot in the beginning. Sealing is necessary to protect highly sensitive medical information. Bitch, it's all out there now. And to prevent foreseeable and substantial harm stemming from the public dissemination of these materials. Well, I guess whoever posted this or allowed it to be retrieved violated the HIPAA, you know, since they're all her doctors. As outlined above, petitioner has been subjected to a pattern of coordinated online online harassment and targeted exploitation of her court filings. Ma'am, they're public court filings. You knew this when you filed it. The risk of further public exposure, especially involving the deeply personal medical diagnoses and treatment details contained herein, is not hypothetical. Prior pleadings have been obtained and weaponized in online forums, triggering renewed waves of harassment, body shaming, and emotional abuse. Lady, nobody's emotionally abusing you. You choose to enter these discords. You have to be invited to these discords. You choose to go on this Reddit, which you know is talking about you. You choose to watch these YouTube videos. You choose to read these comment sections. That is on you. Nobody is sending it. If they're sending it to your inbox, that's different, but it's not happening.
Yeah, that would be harassment. Exploitation's also the wrong word. Exploitation would be doing something to somebody who can't consent or is in a power dynamic that is unequal. A publicly available court document is not a matter of consent or a power imbalance. There's no exploitation that can actually happen.
Right.
So I don't understand why she's using that word.
And there's you and me, Bruce.
Hey, we did it. What's
Under
happening?
Rule 2.550D, the court may seal records where a compelling interest supports sealing. The interest would be prejudiced by disclosure. The proposed sealing is narrowly tailored. It is not narrowly tailored, lady. And no less restrictive means are available to protect the interest. All right. And then, of course, she searched me up there, court of random opinion, because she's in love with me. And
why is this screenshot here?
What's that?
What does this screenshot have to do with anything? What is it?
Nothing. As this con artist, Laura Owens, crashes out and wants her victim prosecuted. She says that somehow had something to do with, what was it? Within 24 hours of the denial, she says that was my retaliation for the court denying my media request, which, again, I didn't tell anyone about or didn't think twice about until it hit the docket and we were all confused because it said Laura Owens made a media request, but it was actually me.
Yeah. But why is it way down here on the next page? I don't...
Because she's fucking stupid.
This is like that thing in Microsoft Word where you try to insert an image and it puts it like halfway to a bio or something. And you're like, what's going on?
Right.
Yeah.
Petitioner submits that compelling interests, including medical privacy, personal safety, and protection from retaliatory online abuse. Abuse is a lot. Warrant sealing this motion this motion is not sealed, bitch. Warrant sealing this motion pursuant to California rules, blah, blah, blah. As this court is already aware, petitioner's July 9th DVRO renewal filing was obtained and disseminated, as public filings are, on social media within 24 hours of submission, resulting in a surge of harassment and public ridicule. So if you don't want to be ridiculed, don't fake pregnancies and medical conditions.
You know the real crime here, Lauren, in the screenshot up there?
Oh boy, what is it?
She never hit the like button. The thumbs up button.
Or subscribed.
What the heck?
Wow.
What the?
Wow.
That's the real crime here.
What a bitch. All right. The relief petitioner is seeking in this matter does not turn on her credibility. Homie. Oh boy. Okay. It does not require the court to assess competing narratives or weigh disputed facts. Respondent has already publicly admitted on video that he knowingly traveled across state lines to appear at a court hearing in violation of the active domestic violence restraining order. Okay. He acknowledged under no uncertain...
Is it a red flag to say, hey guys, don't worry about my credibility. It's not important. Yes! Do you guys think that's a red flag? I don't know.
A little bit. All right. Where were we at here? He acknowledged that under no uncertain terms that he had no intent to testify. He didn't say he had no intent to testify, and therefore appeared solely for the purpose of intimidating petitioner, a calculated act that violated both the letter and the spirit of the DVRO. You want to talk about what violates the DVRO, Laura, is lying about domestic violence. When the restrained party openly admits to conduct that breaches a protective order, the protected party's credibility is no longer material? What? It does if you're lying about it? What? Somebody help me out here. I'm frustrated.
I mean, she's not saying anything about him having the subpoena. And so that is null and void right there. One restrained party openly admits to conduct that breaches, so that he's saying that he went there, but he had a subpoena and he could have been in legal trouble had he not answered that subpoena and attended.
Right. Okay. The violation stands on respondent's own words and actions. In such a case, requiring live testimony from petitioner who suffers from documented neurological and psychological conditions arising in part from respondent's abuse would serve no evidentiary purpose. Dude, it would only expose her to re-traumatization and contradict the protective intent of the DVR or the DV Prevention Act and the ADA. Really, the ADA. You're bringing the ADA into your bullshit.
I think she mentioned it at the beginning as well. Yeah.
Yeah.
I don't get where she's coming from by trying to say, however many years later, that can you guys hear me all right?
Yeah.
Yes.
Okay. That she has these issues stemming from his abuse when she didn't claim them in 2018 and didn't claim them in 2020. How does he know, and how does the court know that she didn't get in another car accident, or she didn't have another quote unquote like abusive relationship, or that she didn't fall off a fuck ton of horses, because she's definitely on video doing that a lot.
Yep. My goodness. All right, where are we here? The law does not compel survivors to suffer. Oh, okay, we can skip over that then because you're not one. Respondents admitted violation combined with petitioner's medical vulnerability and the credible threat of continued harassment constitute compelling grounds for relief. For these reasons, blah, 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 blah. Signed, Laura Owens. All right. Well, that was about the stupidest fucking thing I've read in a while. And I had to respond to Blake Lively's subpoena, so that's saying something. Just saying. Guys, it is 12:03 here, and after getting through all that, I'm tired and ready for bed. So I'm gonna have to call it a night. But let me run through these. It's
fucking exhausting.
First. Yeah, let me run through these first. Elizabeth Wilson, thank you for becoming a member. I appreciate you. Angela Sullivan, thank you for the $2. Lauren, why are people always coming for you? Man, I don't know. I'm very controversial lately. It's kind of weird because if you know me in person or at all in my real life, I'm like very nice and understanding and accepting of pretty much everybody. And now I have all these internet people coming after me, and it's very strange. But it's something I have to learn to live with. So thank you for the $2. And also thank you for the $1 super sticker, Angela. I appreciate it. Did somebody say Excel spreadsheet? Cat Lady Ballerina, Lord of the Spreadsheets. Thank you for the $2. I appreciate it.
Heck yeah.
Zach, thank you for the 2. Bruce owes me child support. Jinkers available.
Well, see, I used a $2 coupon, so $1.99. He owes me a penny.
For child support? Good Lord.
Yeah, you know, it's we're on the discount plan. Imaginary twins, they don't cost much.
Just Ricardo,
you don't file a paternity case.
Just Ricardo, thank you for the 2 for the preemie coughs. I mean, Pacer Fund. Thank you. It will go towards the Pacer Fund and not towards a Pornhub Premium. Thank you very much. Omar started that. I do not use Pornhub Premium. Omar's a liar. Marissa F. will
at least not in the last 2 hours.
Will Mike be allowed to bring up her current charges from Arizona? I don't know.
Abso-fucking-lutely.
Okay,
Abso-fucking-lutely. And I have a feeling he will.
Thank you for the $5, by the way. Elaine Murray, thank you for the 10 pounds. If she hadn't told her fable to the sun, I wouldn't have known anything about this car crash. It's been gripping. Exactly. It's her fault. It's her own fault. Rach G, thank you for the 5. I got a call so behind. If they are mentioning appeals, it was definitely written by Chingris. Thank you. K Rob, thank you for the 10. To Lauren's point, my son, who has been diagnosed as on the spectrum, has told me he finds being social online much easier than in person. Face-to-face is very difficult for him. I agree. And I think that honestly ties a little bit into what I was saying earlier, which is why it's so important for people to get an initial diagnosis in person. I think that our interactions online, although way more commonplace now than it was, even 10 years ago, they're very different. Then like in person and online is very different still. So that's why diagnoses in person are, in my opinion, the best way to go. I'm not saying that nobody should ever see a telehealth provider. I'm just saying most people, for the widespread population, it's going to be go see somebody and get this figured out because you want to make sure you get a correct diagnosis, especially with this kind of stuff. Thank you for the 10, by the way. Marissa F, thank you for the $5. I want Laura in jail, full stop. She can't hurt people from jail. I mean, she could hurt her roommate, I guess. Her cellmate. Thank you.
You mean Jan?
Yeah, right. Jermaine Down, thank you for the $5. What's the over-under she's forced to reveal the real reason she can't testify in person? That she needs leave of court to leave Arizona. That's actually really funny.
Oh, she can't get a permission slip, a hall pass.
I think they would. I think they would give her leave to testify. They probably would, right? I mean, I'm assuming they would.
Why not?
Yeah. Yes, they would.
Thank you, Jermaine, for the $5. All right, guys, we're gonna sign off for tonight. Appreciate it. Thanks for everyone who stuck around. I know I made this longer than it should have been, but oh well. All right. Thanks, everyone. Bye.
Bye.